says, though you are interested to file patent in India, but your idea, your concept, novel across the world. Due to this globalization, as I said, due to this globalization, अभी वो cross borders रही नहीं है, भले physical borders है country to country, but knowledge के ये economy में कोई borders नहीं है. Every world become, you can say, one united under this platform of knowledge economy. So that's why we must have to see that our innovation should be novel across the world, though you are interested to file patent in India. That is number one. Second, your invention should be suffice the requirement of inventive steps or say non-obviousness. That means your solution should not be very much obvious to a person skilled in the art. So for example, in case of very simple example of your, you can say, area of your bee farm. Somewhere down the line, some faculty has to do, you can say, the experiment of titrimetric analysis by determining, you can say, the normality of NaOH. So just to determine the normality of NaOH, हम क्या करेंगे? We try to use, you can say, some standard acids. It may be hydrochloric acid and like so on. Normal case, we use the hydrochloric acid to determine the normality of NaOH. Now, suppose, let's assume a hypothetical situation wherein HCl is not available. CP कॉलेज में HCl का जो स्टॉक था वो खत्म हो चुका है, बट एक्सपेरिमेंट सर को करवाना है, क्या करेंगे? Can we stop the experiment or can we think beyond? तो आपका जो शायद लैब का अटेंडेंट भी होगा या लैब असिस्टेंट भी होगा, वो भी सर को बोलेगा, डीमल सर को, सर हमारे पास ये दूसरे दो एसिड्स है, इसमें से किसी एक को दे दे तो एक्सपेरिमेंट हमारा चालू हो जाएगा. सो दैट मीन्स अगर ये हमारा प्रॉब्लम था जिसमें हमारे पास एसिड्स अवेलेबल नहीं था, एंड अगर आप उसका ऐसा कोई सॉल्यूशन आइडेंटिफाई करते हो विच इज इवन ऑब्वियस टू अ वेरी सिंपल पर्सन हैविंग अ स्किल इन द आर्ट, so in that scenario your invention is not sufficing the requirement of inventive steps. मतलब वो थोड़ा different होना चाहिए, थोड़ा हटके होना चाहिए. That is what the meaning is. And last but not the least is applicability or industrial utility. वो scalable होना चाहिए large scale के ऊपर. And finally the consumer in the should this 3I principle, then only you can think about patent. अगर ये 3I के filter में से आपका कोई भी invention pass नहीं हो रहा है, that means chances of getting patent is likely to be very less. Okay. Next is how to leverage the IP, and that what the principle of 3P comes in the picture. To leverage the IP, of course, we have to first think about the patent. If it passes the all the 3I principle जो भी हमने just now discuss किया, अगर आपका invention कर रहा है, बहुत अच्छी बात है, आप patent के लिए आगे बढ़ सकते हो, patent file करो. Secondly, patent file करने के बाद patent office खुद उसको publish कर दी है, तो publicity भी आपको मिल जाएगी automatically. And of course, patent भी है आपके पास, publication भी हो चुका है, prosperity will come automatically. So that is what the principle of 3P. हमने एक इक्वेशन यहाँ से स्टार्ट किया था 3I plus 3P. अभी I think you can able to correlate. This is the 3I and this is the 3P. And once you combine these two, you can able to enjoy 3M. Okay. So let's start some basics about the IPR and then more about the patent. So what is an intellectual property? Can we say a currency, somebody having $1 billion in his Swiss bank account? हमारे काफी इंडियन लोगों के स्विस बैंक के अकाउंट्स है, फिर वो मिनिस्टर्स हो या कोई भी हो, तो काफी लोगों के वहां पे है. आई थिंक मैक्सिमम स्विस बैंक्स में अकाउंट्स जो हमारे इंडिया के हैं. So can we say all these persons are having a so much high amount of intellectual property? Of course not. You can write all in the chat box also if you wish parallelly. So answer is no, because currency can be availed by various, you can say, means, right? But if you have intellectual property, of course you can able to generate more amount of the currency or a revenue, but it is a byproduct. It itself is not intellectual property. Am I right? Currency itself is not IP, but you can generate the currency if you have IP. Second question, gold. If we have a 10 kg of gold, then can we say that gentleman or that women having a more intellectual property? Of course not. मोदी जी जैसे नोटबंदी की थी, उसके बाद वो सोच भी रहे थे कि now he will think about restriction on a gold amount, right? But due to this election, other things, he has not declared it. But अगर 2024 क्लियर हो चुका हो गया in future, of course that will come also in the he as one of the agenda. वो आएगा शायद कि आपके पास इससे ज्यादा अगर गोल्ड है तो आपको डिक्लेयर करना पड़ेगा, उससे ज्यादा आप रख नहीं पाओगे, जैसे नोटबंदी में पूरे नोट्स उन्होंने बंद कर दिए. Anyhow, but the point is, if somebody having a very large amount of gold, can we say that that person is having a more IP? Of course not. Just like in the previous we have discussed about the currency. If you have an IP, you can generate n number of kg of golds, but gold itself is not IP. Similar way, house, can we say it is an IP? Yes. Previous. And if somebody having a 10 acre of lands, maybe nearby to your university campus, having a valuation of almost 20 crore, though it is a very good amount, but we can't say that due to having possessing this land, that gentleman who has only, you can say, studied up to the 4th standard, it's having a that much level of intellectual property, right? He maybe got this land from his fathers or forefathers, right, due to his family tradition, but it is not IP itself. Next, idea. Can we say idea is an intellectual property? Yes. So we can bifurcate the property in a two type, tangible and intangible. Tangible, that which can be seen, measured, touched and having a physical form, जो हमने सब अब तक देखा है, currency, gold, house, land, industry. आप जहाँ भी कॉलेज में स्टडी कर रहे हो, पूरे कॉलेज का कैंपस, यूनिवर्सिटी का कैंपस, दिस ऑल आर, यू कैन से द टेंजिबल प्रॉपर्टी of your, you can say, college as well as the university, and it can be quantifiable. What would the valuation of entire Charutar, you can say, university? That maybe it having a say 200 acre of land, having a almost, you can say, 100 buildings, including the you can say the guest house and everything, laboratories and whatever the, you can say, the physical things we can able to see, that everything comes under the, you can say, the umbrella of tangible property of the university. But intangible, that which cannot be measured, which cannot be touched, which cannot be seen also, and that is what coming from the creation of human mind or intellect, and that is what example is the ideas. अगर हम मान ले कि कल उठ के किसी फॉरेन यूनिवर्सिटी को पूरा ही एक बहुत बड़ा इन्वेस्टर, और उनको पूरी यूनिवर्सिटी, आपकी यूनिवर्सिटी काफी ओल्डेस्ट है, बोल सकते हैं ओल्डेस्ट यूनिवर्सिटी भले ही नहीं है, बट आपका जो कैंपस है वो काफी ओल्डेस्ट है, ऑलमोस्ट आई थिंक मोर देन 70 years. Many times I visited and I have been invited to your campus by various institute of your campus. So जो उनकी लेगेसी है उसको ध्यान में रखते हुए अगर उनकी टेंजिबल प्रॉपर्टी का अगर क्वांटिफिकेशन करे, having, as I said, 200 acre of land or all this building, say for example it having a valuation of 1000 crore, but अगर किसी को पूरा ही चारुतर यूनिवर्सिटी को परचेज करना है, जैसे कोई फॉरेन इन्वेस्टर, उसको इंडिया में इन्वेस्ट करना है एजुकेशन सेक्टर में, आज की तारीख में देखें तो काफी इन्वेस्टमेंट इंडिया में आ रहा है, पर्टिकुलरली इन द एजुकेशन सेक्टर ऑल्सो lot of foreign investors are investing in India. तो मान लीजिए किसी को इन्वेस्ट करना है ऐसे अच्छे एजुकेशन कैंपस में, अगर उनको ये टेंजिबल प्रॉपर्टी का एनालिसिस करे तो 1000 crore may be the value. But does it mean everything is covered under this? No, because this Charutal, you can say, university has gained, you can say, the fame and you can say credibility. उसकी भी एक वैल्यू होती है, वहाँ के जो फैकल्टी है, वहाँ के जो रिसर्चर्स है, वहाँ का जो रिसर्च अभी तक का पब्लिश हुआ है, कुछ पैटर्न्स भी आई थिंक आपके यहाँ से हुई है, अगर उन सब का भी क्वांटिफिकेशन किया जाए, सो दैट कंप्राइजेस ऑफ द इंटेंजिबल एसेट ऑफ योर इंस्टीट्यूट और से यूनिवर्सिटी, और ऑफ कोर्स उसकी भी वैल्यूएशन होती है। ऑफ कोर्स इन इंडिया ये हमारे लिए ये चीज थोड़ी नहीं है, बट अगर फॉरेन यूनिवर्सिटीज की बात करें, यू नेम इट लाइक हार्वर्ड और ऑक्सफोर्ड और MIT, तो वहां का अगर टेंजिबल प्रॉपर्टी का जो वैल्यूएशन है उससे कहीं गुना ज्यादा वैल्यूएशन उनके इंटेंजिबल एसेट्स का होता है। We'll discuss some of the example in later part of my presentation, but the value of intangible property is sometimes you can say 50 to 100 times more than the tangible property. कितना मैंने बोला, मैं कोई hypothetical figure नहीं बोल रहा हूँ, 50 to 100 times. If your intangible property is so much strong, तो 50 से 100 गुना ज्यादा भी आपको मिल सकता है as compared to your tangible property. Okay, we'll discuss example later on, but now let's see which are the types of IP. It comes, you can say the ideas or a process or a product, design, literary artistic work, logo, brand name, symbol, all these are comes under the form of, you can say, different forms of intellectual property. ये सभी अलग अलग टाइप की प्रॉपर्टीज है। आपके पास कोई आइडियाज भी है, कुछ आपने प्रोसेस डेवलप की है, कुछ अगर आप प्रोसेस के माध्यम से कोई नई प्रोडक्ट भी बनाते हो, यू आर फ्रॉम फार्मेसी, बट अगर कोई इंजीनियरिंग में काम करता है तो वो डिजाइन एलिमेंट्स के ऊपर काम करेंगे। अगर हम फार्मा की ही बात करें अभी, तो नाउ यू नो द कंसेप्ट ऑफ 3D प्रिंटिंग। 3D प्रिंटिंग में हम क्या करते हैं, बेसिकली वी कम आउट विद द इनोवेटिव डिजाइन ऑफ द फॉर्मुलेशन, फिर वो टेबलेट हो, कैप्सूल हो, उसकी भी अलग अलग हम डिजाइन कर सकते हैं। उसका जो पैकेजिंग है उसकी भी अलग अलग डिजाइन हम कर सकते हैं। So some of you might be interested in this novel concept of pharmacy, like utilizing the concept of 3D printing. तो डिजाइन आपके लिए भी इतना ही important tool रहेगा वो माध्यम से। पैकेजिंग हो गया, कॉस्मेटिक्स प्रोडक्ट्स हो गई, तो वहां सब जगह पे ये डिजाइन एलिमेंट इज वेरी मच इंपॉर्टेंट। ऑफ कोर्स इफ यू आर इंटरेस्टेड इन लिटरेरी वर्क, लाइक अगर आप रिसर्च पेपर्स या प्रेजेंटेशन करते हो, तो इट इज कम्स अंडर दैट। If you have some, you can say, soft skills like artistic skills, it comes under the artistic word. And if you have some kind of, we can say, crafting skill or drawing skill like logo, brand name, etc., it comes under the last part. But very important is, if you have IP, you must have to register your IP using all these different 8 tools available in front of your screen. आपके पास IP है, लेकिन अगर आपने IP को प्रोटेक्ट नहीं किया है, that means that IP is open to all. कोई भी उसका यूज कर लेगा, यूज भी करेगा, मिसयूज भी करेगा, और आपको एक्नॉलेजमेंट भी नहीं करेगा, because you have not sought the protection from the government. And that's why government has framed various forms of rights under the umbrella of IP. That's why it is known as IP rights, जो हम short में IPR बोलते हैं. These are nothing but the various tools: patents, trademarks, copyright, design, geographical indication, semiconductor circuit layout design, plant variety and breeders' rights, and last but not the least is a trade secrets. And these are nothing but, you can say, various, you can say, acts under which government of India is protecting all different forms of IPR in India. And this is the, you can say, illustrative examples of various forms of IPR. कॉपीराइट की बात करें तो लेफ्ट साइड में आप देखेंगे कि एक टेक्स्ट बुक्स आपको दिख रही है, उसका फ्रंट पेज है। एक भाई साहब है जो कुछ गाना चाह रहे हैं, समझ तो नहीं पा रहे अभी क्या गा रहे हैं, बट एवरीबडी माइट हैव सीन हिम एंड लिसन हिम, वेरी ब्यूटीफुल सॉन्ग्स एंड लिरिक्स ही इज मेकिंग. सो all these forms of, you can say, creations or IP can be protected by means of copyright. लेफ्ट बॉटम साइड में आप देखेंगे तो कुछ डिजाइन है, कार की है, कुछ मोबाइल्स की है, that can be covered under the umbrella of the industrial design. जैसे मैंने अगर फार्मा की बात की आपको, तो फार्मास्यूटिकल पैकेजिंग की बात करें या उसके प्रोडक्ट के जो शेप की बात करें, that also comes under the, you can say, the industrial design. अगर आप टेबलेट का कोई नया उसका स्ट्रक्चर्स बनाते हो या फिर उसका पैकेजिंग एकदम इनोवेटिव करते हो, अट्रैक्टिव करते हो, that can come under the design protection. राइट टॉप साइड में आप देख रहे हैं कुछ प्रोडक्ट्स है, बहुत वेल नोन प्रोडक्ट्स है, सो दैट कम्स अंडर द, यू कैन से, द अम्ब्रेला ऑफ द ट्रेडमार्क रजिस्ट्रेशन. राइट बॉटम साइड में आप देखेंगे कि यू कैन सी द दार्जिलिंग टी, केसर मैंगो एटसेट्रा. सो दीज आर नथिंग बट जियोग्राफिकल इंडिकेशंस. राइट साइड में आप फिर से देखेंगे ट्रेड सीक्रेट्स, द फॉर्मुलेशन ऑफ कोका कोला, पेप्सी. ऑलमोस्ट 100 years ये दोनों प्रोडक्ट को हो चुके हैं, बट आज की तारीख में भी अहमदाबाद में भी काफी कोला बनाने वाले हैं, आपके आनंद में भी काफी कोला बनाने वाले होंगे, विद्यानगर में भी होंगे, बट द कोका कोला टेस्ट और टेस्ट ऑफ पेप्सी इज समथिंग यूनिक। आज की तारीख में भी कोई इसको एग्जैक्टली कॉपी नहीं कर पा रहा है, बिकॉज दे हैव नॉट gone with the route of a patent, they have gone with the route of, you can say, the trade secret. Only the big companies can able to do so, right? But let's focus more on a central part, that is a patent, which basically required to protect the scientific inventions जहां आप और हम काम कर रहे हैं. So let's see something brief about patent Indian perspective. What is patent? कुछ लोगों को आइडिया है, कुछ को नहीं है. So let it try to summarize what is exactly the patent. So patent is nothing but an exclusive right or say negative right. क्या है? अगर पेटेंट आपको मिल जाती है तो you can exclude all others. That is known as exclusive right. गवर्नमेंट आपको एक राइट देती है कि जिसके माध्यम से आप बाकी सबको एक्सक्लूड कर सकते हो. Second important is it is also the negative right. So this is, I think, only the one right which government is giving as a negative right. बाकी majority of the rights which government is giving is a positive right. So for example, आप कोई नया बाइक लेते हो, नई कार लेते हो, तो क्या करते हैं हम we go to the RTO office, we do the registration, and then after that car or bike belongs to our name legally, right? And you can start immediately utilizing your car or bike, whatsoever may be that you have purchased. And that means it is a positive right given by the government. Similar way, अगर आपने कोई नया बंगलो खरीदा है, नया फ्लैट खरीदा है, जैसे ही आप उसका रजिस्ट्रेशन करवाते हो सब रजिस्टर ऑफिस में, that property now becomes officially on your name. You can start utilizing your property. और कल उठ के कोई भी उसका ट्रे पासिंग करता है, आपकी प्रॉपर्टी में आता है, you can sought the help from the government because now the legal right has been given to you. So that is a positive right. आप 18 प्लस के हो, आपके पास इलेक्टोरल राइट्स मिल जाते हैं आपको, आपके लिए उसका जो भी प्रोसीजर आपको करना है. So that is a positive right government is giving. So as I said, almost all the rights government is giving to us are positive. मतलब एक बार उन्होंने सिक्का मार दिया कि ये प्रॉपर्टी आपके नाम की है, फिर वो बाइक हो, स्कूटर हो, या घर हो, या बंगलो हो, या जो भी हो, that means you can start immediately utilization of your rights. Am I right? Because it is a positive in nature. But यहाँ अगर पेटेंट की बात करें, जो काफी लोग को समझना जरूरी है, अगर जिनको पेटेंट में आगे बढ़ना है, पेटेंट फाइल भी करनी है, पेटेंट इज अ नेगेटिव राइट. इट इज ओनली राइट गिवन बाय द गवर्नमेंट एज इन अ नेगेटिव फॉर्म. क्या इसका मीनिंग हुआ कि आपको राइट, मान लीजिए कल उठ के आपने पेटेंट फाइल किया, आज काफी लोग मोटिवेट हो चुके हैं, अच्छा आविष्कार भी आपके ध्यान में है, आपके पास से आपने पेटेंट फाइल भी की, 2 साल 3 साल के बाद पेटेंट आपको ग्रांट भी हो चुकी, एंड इफ यू देन थॉट कि बॉस पेटेंट आपके पास मिल चुकी है, सर्टिफिकेट्स गवर्नमेंट ने दे दिया, लेट्स स्टार्ट यूटिलाइजिंग योर पेटेंट, देन यू मिस द वेरी इंपॉर्टेंट एलिमेंट ऑफ पेटेंट. पेटेंट इज नॉट अ पॉजिटिव राइट, इज अ नेगेटिव राइट. लेट्स अंडरस्टैंड विद वेरी ब्रीफ एग्जांपल. मान लीजिए एक मैं मोबाइल का एग्जांपल दूंगा, क्योंकि आज सभी लोग मोबाइल के बिना उठते भी नहीं है, मोबाइल के बिना सोते भी नहीं है, राइट? सो मोबाइल की अगर हम बात करें तो फॉर इंस्टेंस एप्पल का i13 अभी है, राइट? i13 सीरीज ऑलरेडी है अवेलेबल. कोई ऐसा कोई इनोवेटर्स है जिन्होंने एक अच्छा आविष्कार करना स्टार्ट किया, for which the technology he has used initially from the Apple only, but he has developed some more innovative elements जो अभी तक i13 में भी नहीं है, और उन्होंने कुछ एलिमेंट्स अच्छे बनाए अपने मोबाइल को. जब वो रिसर्च कर रहे थे, उन्होंने पेटेंट भी फाइल की. मान लीजिए वो हमारे गुजरात की ही है, स्टार्टअप्स है कोई, पेटेंट भी उन्होंने फाइल की, पेटेंट उनको शायद ग्रांट भी हो चुकी इंडियन पेटेंट ऑफिस से. क्या होगा? ऑफ कोर्स दे विल फील वेरी हैप्पी कि बॉस हमारे पास ऐसी इनोवेटिव टेक्नोलॉजी हमने डेवलप की है जो आज तक एप्पल के i13 में भी नहीं है, और वो टेक्नोलॉजी आज हमारे पास है. अच्छी बात है, नो डाउट अबाउट इट, और पेटेंट भी मिल चुकी है, दैट इज आल्सो वेरी गुड पार्ट, नो डाउट अबाउट इट. क्या हुआ? उन्होंने स्टार्टअप में तो ऑलरेडी रजिस्ट्रेशन था, फंडिंग एजेंसीज को भी अप्रोच किया, इंक्यूबेशन सेंटर्स को अप्रोच किया, कुछ एंजल इन्वेस्टर भी उनको मिल चुके. उन्होंने शायद उनको इन्वेस्टमेंट मिल भी गया, इनिशियल यू कैन से सीड इन्वेस्टमेंट एंड देन एटलीस्ट अप टू सम कैपिटल इन्वेस्टमेंट टू स्टार्ट द बिजनेस। करीबन 1 करोड़ का फंडिंग लेके उन्होंने बिजनेस स्टार्ट किया। गुड, 2 साल अच्छा उन्होंने मार्केट कैंपेन भी किया, बिकॉज टेक्नोलॉजी वाज समथिंग टोटली न्यू, क्योंकि कहीं भी नहीं थी ऐसी टेक्नोलॉजी और उनके प्रोडक्ट्स में ये टेक्नोलॉजी थी। अच्छा मार्केट भी उनको मिल गया, 2 साल 3 साल अच्छा मार्केट में उनको रिस्पॉन्स भी मिलने लगा। ऑफ कोर्स आपको लगता होगा कि भाई तो एप्पल क्या कर सकता है ये केस में, क्योंकि बेसिक टेक्नोलॉजी एज आई सेड दे हैव स्टार्टेड विद द बेसिक प्लेटफॉर्म ऑफ एप्पल ओनली। एप्पल अभी तक उसको कुछ टच भी नहीं कर रहा था। ये हमारे गुजरात के जो स्टार्टअप्स हैं उनको बोल भी नहीं रहा था कि भाई आप इसका यूज ना करो या कुछ भी ना करो। 3 साल उन्होंने वो सिर्फ ऑब्जर्व किया, उनको मैच्योर होने दिया। फिर क्या होगा, 3 साल के बाद एप्पल विल सेंड वन काइंड ऑफ यू कैन से लेटर। ऑफ कोर्स वो लेटर में लीगल लेटर होगा जिसमें लिखा होगा कि भाई साहब आप जो टेक्नोलॉजी का उपयोग कर रहे हो उसमें बेस में, उसके फंडामेंटल में जो भी टेक्नोलॉजी है वो हमारे एप्पल की है और उसकी हमारी सो एंड सो पेटेंट्स है। दैट मीन्स कि दो सम ऑफ योर एलिमेंट्स आर नोवेल, ऑफ कोर्स वी नॉट डिनाई इट, बट टू यूज योर यू कैन से एलिमेंट्स, आपका जो बेसिक एक प्लेटफॉर्म होना चाहिए कोई भी टेक्नोलॉजी का, वो तो हमारा ही है। तो विदाउट बेस अगर आपने टॉप फ्लोर चुन लिया है, सिलेक्ट कर लिया, आप कैसे जा सकते हो टॉप फ्लोर में? अगर आपका 1 से 10 माला का मंजिल मेरा है और 11 माला का मंजिल ही आपका है, सो यू मस्ट हैव टू पास थ्रू 1 to 10 फ्लोर व्हिच बिलोंग्स टू मी। सो देन एप्पल विल फाइल यू कैन से द लीगल सूट, और वो इतना बड़ा लीगल सूट फाइल करेगा कि सामने वाली जो हमारी स्टार्टअप की कंपनी थी उसको देयर इज नो ऑप्शन टू गेट onto the you can say the mode of settlement। वो बोलेंगे एप्पल वाले, भाई साहब आप जितना भी रेवेन्यू जनरेट किया है उसका मुझे इतना परसेंटेज चाहिए, आप पूरी टेक्नोलॉजी आप हमें दे दो, बिकॉज दिस बेस टेक्नोलॉजी है, उसके विदाउट तो आप प्रोडक्ट आपकी मार्केट में जा ही नहीं सकती। आपने जो भी बेचा है वो क्राइम किया है, एंड दैट इज ट्रू, बिकॉज गवर्नमेंट ऑलरेडी सेइंग बॉस हम आपको जो राइट दे रहे हो नेगेटिव है, आपको ड्यू डिलिजेंस करना है कि आपने जो टेक्नोलॉजी डेवलप की है उसके रिलेटेड कोई दूसरी टेक्नोलॉजी है कि जो आपसे ओवरलैपिंग हो या आपके एज ए बेस के तरीके काम कर रही हो, तो आपको मस्टली उनके साथ डिस्कस करके उनसे क्रॉस लाइसेंसिंग लेके ही काम करना है। एंड दैट्स व्हाई आई सेड कि गवर्नमेंट हैज वेरी मच क्लैरिटी। हमें शायद क्लैरिटी ना हो, जैसे ये स्टार्टअप को नहीं थी, तो उनका 3 साल की मेहनत 50 करोड़ अभी तक उन्होंने रेवेन्यू जनरेट किए, हो सकता है कि पूरा ही उनको वाइंड अप करना पड़े। तो आप लोगों के साथ ना हो, इसलिए मैं थोड़ा इसको इलाबोरेटली आपके साथ मैंने डिस्कस किया। ओके ओके, लेट्स गो टू द नेक्स्ट। सो इट इज राइट बाय स्टैट्यूट और अ लॉ। पेटेंट इज अ राइट बाय लॉ ऑफ कोर्स, एंड इट इज अ टेरिटोरियल राइट्स। दैट मींस अगर आपने इंडिया में पेटेंट फाइल की है तो यू कैन साउट द प्रोडक्शन इन इंडिया। एनीबडी इन बांग्लादेश, पाकिस्तान, चाइना can able to use your technology without any you can say asking to you, without paying a single penny। तो बॉस हमारे पास काफी ऐसी टेक्नोलॉजी है जो वर्ल्ड डेवलप कर रहा है, यूएस काफी टेक्नोलॉजी डेवलप कर रहा है, चाइना भी काफी उससे भी फास्ट टेक्नोलॉजी डेवलप कर रहा है। अगर हम उनका टेक्नोलॉजी अगर उन्होंने इंडिया में प्रोडक्शन नहीं लिया है, एटलीस्ट वी कैन स्टार्ट यूटिलाइजिंग दैट टेक्नोलॉजी इन इंडिया। और हमारे जो मैन्युफैक्चरर्स है, फार्मास्यूटिकल स्मॉल स्केल मैन्युफैक्चरर्स है, एमएसएमई, क्योंकि आप लोग बी फार्म एम फार्म के बाद कहीं ना कहीं आप जॉब में जाओगे। सम ऑफ यू ऑफ कोर्स विल स्टार्ट योर ओन स्टार्टअप, बट अगर जिनको कहीं ना कहीं इंडस्ट्री में आना है उनके लिए बहुत अच्छा ये माध्यम है। अगर ये एक एंगल को अच्छी तरह समझ ले और ड्यूरिंग व्हेन यू फेस योर इंटरव्यू, अगर आप ये चीज के बारे में थोड़ा इंटरव्यूअर को बता पाओगे कि दिस आर द टेक्नोलॉजी which is available in China or US or Germany or Japan but not available in India, and our company, that means आप जो कंपनी में इंटरव्यू देने जा रहे हो and you can suggest them कि सर ये हमारी कंपनी में अगर ये टेक्नोलॉजी का हम उपयोग करेंगे, nobody can stop us, because उन्होंने इंडिया में प्रोटेक्शन लिया नहीं है आज की तारीख में, तो we can use their platform totally free, right? तो patent or patent search you can also use when you are going for your interview, and it will give you a lot of boost up and very strong positive impact on the front of interviewer. Okay, next is patent is a time limited right, 20 years. Of course there are two type of patent: product patent, process patent, and third is a use patent. Of course it is not applicable in India. फॉर एग्जांपल यूज पेटेंट की बात करें तो ड्यूरिंग दिस कोविड सिचुएशन आई थिंक at initial juncture WHO has given a kind of, you can say, recommendation कि you start using hydroxychloroquine, तो classical antimalarial product है, उसका use हमने start किया, right, for the COVID treatment के लिए, and sequentially काफी, you can say, repurposed drugs for the COVID market में आने लगी, recommendation by the WHO and ICMR के माध्यम से. But the point is कि अगर किसी ने इसके ऊपर रिसर्च किया है कि भाई ये प्रोडक्ट भी जो रीपर्पस्ड है वो भी यूज हो सकती है, फर्स्ट टाइम अगर उन्होंने यूज आइडेंटिफाई किया, एंड इफ दे वांट टू गेट अ पेटेंट इन इंडिया, इट इज नॉट अलाउड, क्योंकि इंडिया में हम यूज पेटेंट को ग्रांट नहीं करते हैं, न्यू यूज ऑफ द एग्जिस्टिंग प्रोडक्ट. सो व्हाट आर द सब्जेक्ट मैटर्स फॉर पेटेंट? ओनली यू कैन से द न्यू प्रोसेस और अ न्यू प्रोडक्ट, मेथड ऑफ मैन्युफैक्चर और अ मशीन और apparatus और एनी अदर आर्टिकल्स which suffice the requirement of this 3I. Once again 3I आपके सामने आ रहा है. Innovativeness, now it is very clear to you, I hope, कि सिर्फ आपको गूगल वगैरह क्लासिकल सर्च जो आप कर रहे हो वही नहीं देखना है, पेटेंट के जो स्पेसिफिक डेटाबेसेस है वो भी चेक करके आपको ये चेक करना है कि whether your invention is novel or not. Second is inventive steps, and third is industrial utility. Over and above in India, we have a lot of, you can say, inventions that are not patentable under the section 3 and 4. थोड़ा उसका समराइजेशन है, like law of nature or any discovery related to nature, like Einstein's law, Newton's law, etc. अगर कोई आपने ऐसा डिस्कवरी किया है, it is not patentable. Software, mathematical equation, business model, etc. are not patentable. New use or a new property of non-substance, जो भी हम बात कर रहे थे, हाइड्रोक्सीक्लोरोक्विन की बात कर रहे थे, या उसके बाद भी जो काफी रीपर्पस ड्रग आई, like remdesivir. Remdesivir also not basically meant for you can say the COVID, but that is also as a repurposed drug COVID में use हुई बाद में. So again, all these kind of things are not patentable in India under section 3D. आप कोई भी चीज मिक्स करते हो या दो कंपाउंड को मिक्स करके A+B करके उसकी अगर एडिटिव इफेक्ट आ रही है, of course then it is not patentable. But if you want to mix A+B, then you must have to prove the synergistic effect. Then and then only you can get eligible for a patent, and like so on. I will not go in detail about this, but certain facts. Already we discussed about the 20 years lifespan of patent. In India, we follow first to file. US initially it was following the first to invent, but since 2016 they also converted to first to file. So now you can say entire world following first to file. मतलब आपने आविष्कार मान लीजिए पहला किया है, बट आपके बगल वाला जो आपका कलीग है, अगर वो पहले पेटेंट फाइल कर देता है और आपको मालूम भी नहीं है, then he will enjoy the rights, and that is fact, right? आप उसको स्टॉप नहीं कर पाओगे बाद में. So that's why it is very important that अगर आप कोई प्रोजेक्ट्स के ऊपर काम कर रहे हो, आविष्कार के ऊपर काम कर रहे हो, तो आपको मस्टली, जैसे आपको लगता है कि वो पेटेंटेबल हो सकता है, आपको इमीडिएटली फाइल करना चाहिए. और देयर आर वेरियस प्रोविजंस आर अवेलेबल, लाइक फाइलिंग ए प्रोविजनल. आपका भी रिसर्च चल रहा है, कंप्लीट नहीं हुआ, देन देयर इज ऑप्शन इज अवेलेबल ऑफ फाइलिंग अ प्रोविजनल पेटेंट. वो आई थिंक सब्सिक्वेंट आप जब आप नेक्स्ट सेशन समझोगे तो उसमें आपको बताया जाएगा ज्यादा उसके बारे में, which are the various applications are available to file a patent in India. But classically in India we have 4 patent office: Kolkata, Delhi, Mumbai and Chennai. It comes under the Ministry of Commerce and Industry, under the Department of Industry Policy and Promotion. Under that there is a Control General Patent Design and Trademark, and very recently this is the, you can say, topmost position of this all the, you can say, the various offices of IPR. और उनका एक हेड होता है जिसको हम कंट्रोल जनरल बोलते हैं. अच्छी बात यह है कि अभी रिसेंटली ही गुजरात के ही हमारे एक भावनगर के डॉक्टर उन्नत पंडित साहब, जो यहाँ केडिला फार्मा में थे, मेरे अच्छे मित्र भी है, उनका भी अपॉइंटमेंट हुआ है एज अ कंट्रोल जनरल ऑफ पेटेंट डिजाइन एंड ट्रेडमार्क. सो इट इज अ गुड, यू कैन से, द मूव इन द हिस्ट्री ऑफ CGPDDM, क्योंकि अभी तक ओनली द IAS ऑफिसर्स ही ये पोजीशन के ऊपर जाते थे बाय द अपॉइंटेड बाय द मिनिस्ट्री. बट आई थिंक बहुत कम बार ऐसा देखा गया कि कोई पेटेंट का इतना सीनियर एक्सपर्ट पर्सन को ये पोजीशन पे बिठाया गया हो, एंड हु इज नॉट फ्रॉम, यू कैन से, IAS कैडर. तो बिकॉज ही कैन अंडरस्टैंड द टेक्नोलॉजी पार्ट वेरी वेल. उनके अंडर में सभी पेटेंट ऑफिस आती है। ट्रेडमार्क में भी 4 मेट्रो सिटी इंक्लूडिंग इन अहमदाबाद वी हैव ट्रेडमार्क रजिस्ट्री, geographical industry registries only in Chennai, and patent information system, and there is a National Institute of IPR at Nagpur. पेटेंट का अगर ग्लोबल सिनेरियो देखे, कैन आई गेट ए इंटरनेशनल पेटेंट और ग्लोबल पेटेंट? सर मुझे सिर्फ इंडिया में पेटेंट नहीं करवाना है, मुझे इंटरनेशनल पेटेंट चाहिए, मेरा आविष्कार बहुत बड़ा है and I want to get a global patent. Can I get it? Answer is no. There is no provision as such to get an international patent or a global patent. But there is a platform available called PCT, Patent Cooperation Treaty, which provide a platform to any innovators to file their patent through the PCT, जिसके करीबन 152 are the member countries across the world. तो वो 31 मंथ तक आपके जो पेटेंट एप्लीकेशन है उसको होल्ड करके रखेगी सभी पेटेंट ऑफिस में। मतलब आप इंडिया में बैठ के भी अगर PCT का रूट से आप पेटेंट फाइल करते हो, up to 31 month, your patent priorities will get protected in 152 countries जो member है, उसमें सभी major countries है। And then you have to take a call in which further countries you would like to go for the national filing. फिर आप US में जा रहे हो, जर्मनी जा रहे हो, कहीं भी जा सकते हो, but that decision you have to take within the 31 months. India is also member, 148 पहले थे, आज की तारीख में 152 हो चुके हैं। Okay, so now let's see where we stand globally in terms of innovation. आज की तारीख में हम कहाँ पे है इनोवेशन की दुनिया में? So there is one consortium known as the Global Innovation Index. एक एनजीओ है, वर्ल्ड लेवल की बहुत बड़ी एनजीओ है, जो वाइपो भी उसमें सपोर्ट करता है, और इंडिया से CII, कन्फेडरेशन ऑफ इंडियन इंडस्ट्री, is also supporting this network. Or there is a Cornell University of USA who is also supporting this you can say NGO. ये एनजीओ का काम है पूरे वर्ल्ड के 152 जो भी मेंबर कंट्रीज है उनको मैपिंग करना, उनके 84 डिफरेंट पैरामीटर्स, मतलब हर एक कंट्री के 84 पैरामीटर्स को वो एनालिसिस करते हैं राउंड द ईयर, और राउंड द ईयर एनालिसिस करने के बाद यूजुअली इन अगस्त और सितंबर दे पब्लिश द रैंक कि ये 84 अलग अलग पैरामीटर्स है, उसमें कौन सा कंट्री कहां पे पहुंचा है, और उसका ऑफ कोर्स ओवरऑल एक रैंक भी मिलता है। 84 का इंडिविजुअल भी मिलता है और ओवरऑल एक ग्लोबल 84 का एक रैंक मिलकर उनको एक रैंक भी मिलता है। एंड दिस इज नथिंग बट रैंक जो आपके सामने है, 13, 14, 15, 16 का ये डेटा से आपके सामने, जिसमें आप देखोगे कि स्विट्जरलैंड इज कंसेक्यूटिवली ऑन द टॉप मोस्ट इन टर्म्स ऑफ द इनोवेशन। बाकी सभी कंट्री प्लस माइनस हो रहे हैं। अगर लास्ट ईयर का ही डेटा इसमें देखें, अगेन यू कैन सी GI रैंक ऑन फर्स्ट कॉलम, अगेन स्विट्जरलैंड इज कंसेक्यूटिवली ऑन टॉप 1, जो 2013 से हमने देखा था, अभी तक 2021 में भी वो फर्स्ट पोजीशन अपनी बनाए रखे हुए। स्वीडन और US आगे पीछे हो रहे हैं कहीं ना कहीं। ओके, तो दिस आर द लिस्ट ऑफ टॉप 25 कंट्री। आप देखोगे इसमें ऑन द पॉइंट नंबर 12 चाइना, हमारा नेबरिंग कंट्री, जो एक समय में हमारे साथ ही चल रहा था, आज काफी हमसे आगे निकल चुका है, तो 12 नंबर पे पहुंच चुका है। ओके, आपको कहीं इसमें इंडिया नहीं दिखेगा, राइट? लेट्स सी हम कहाँ पे है इंडिया। अगर हम 2010 से हमारा हिस्टोरिकल डेटा देखें GII का, so in 2010 we were on the 56th, then 62nd, 64, 66, 76, 81st। 2015 में बात करें तो मतलब सेंचुरी नजदीक ही आने वाली थी, right? Century is good in cricket but not good in such kind of, you can say, ranking, am I right? तो 2015 में, as you know, the government in the central side has changed. Our CM become the PM of our country, and then he visualized कि बोस अगर इंडिया को आगे बढ़ाना है तो हमें इनोवेशन में डेफिनेटली आगे बढ़ना पड़ेगा। एंड फर्स्ट टाइम वो जब मई 2015 में PM बने, इमीडिएटली ऑन अ सेम ईयर in, you can say, the December 2015 only, is within a span of 6 or 7 months, इंडिया की फर्स्ट IPR पॉलिसी ड्राफ्ट होके पब्लिश हो चुकी थी। मतलब यू कैन इमेजिन कि उनको कितना विजुअलाइज था कि अगर नॉलेज इकोनॉमी में जो बात कर रहा था आपको, बिकॉज ही अंडरस्टैंड कि ये दिस डिकेड इज नॉट ओनली मियर टू स्ट्रेंथन अवर आर्मी जो बॉर्डर्स के ऊपर हम कर रहे हैं, बट नॉलेज के फ्रंट पे भी हमें काफी वर्क करना पड़ेगा, क्योंकि ये लड़ाई जो नॉलेज की है वो सबटल लेवल पे है, जो दिख नहीं रही है, बट उसके लिए अलग अलग चीजों हमें करनी पड़ेगी, तभी हम वर्ल्ड लेवल पे कॉम्पीट कर पाएंगे। और इमीडिएटली यू कैन सी 2015 में जो हम 81st रैंक में थे, उनके आने के बाद काफी उन्होंने जो अलग अलग पॉलिसी स्टार्ट की, लाइक स्टार्टअप पॉलिसी, स्टैंड अप पॉलिसी, मेक इन इंडिया, राइट, lot of you can say the changes have been done, and lot of you can say the revenue resources के पहले तो भाई रिसर्च करने के लिए फंड मिलना मतलब बहुत जैसे चांद तारे तोड़ने जैसी बात होती थी जब हमारे समय में हम लोग रिसर्च करते थे। बट आज आपके लिए इतनी बड़ी कोई चैलेंज नहीं है। अगर आपके पास अच्छा आइडिया है, अच्छा आविष्कार करने की तमन्ना है, अलग अलग काफी माध्यम से, आपकी कॉलेज में भी आई थिंक इंक्यूबेशन सेंटर्स या यूनिवर्सिटी में इंक्यूबेशन सेंटर होगा जो आपको एटलीस्ट एक सीड फंड दे देगा 25,000, 50,000, 1 लाख, तो आपका एक बेसिक रिसर्च आप एटलीस्ट स्टार्ट कर पाते हो। एंड दैट इज बिकॉज गवर्नमेंट इज नाउ रियलाइजिंग कि बॉस अगर हम ये इंक्रीमेंटल सपोर्ट नहीं करेंगे तो हम आगे नहीं बढ़ पाएंगे। एंड आई थिंक ड्यू टू दैट रीजन ओनली यू कैन सी द ग्राफ which was inclining towards the century, now gradually it comes less than 50, 66 आया, 60, 57, 52, 48, 46, though it is a slow reduction, slow growth है but sustained growth है, that is important। even during this COVID also our growth has been there in terms of innovation। but ये जो पाई चार्ट है वो मैं आप सबको थोड़ा बताना चाहूंगा। it is still though government is trying their level best, उनका काम है अलग अलग पॉलिसी की फ्रेमिंग करना, सपोर्ट करना इन टर्म्स ऑफ यू कैन से फाइनेंशियल थिंग्स एंड रेगुलेटरी पार्ट, बट कहीं ना कहीं हमारा रोल भी इसमें मेजर है। अगर गवर्नमेंट है आर्मी को अच्छे से अच्छे आर्म्स दे दे, राइट, अच्छे से अच्छे उनको प्रोटेक्टिव डिवाइस दे दे फाइट करने के लिए, बट अगर आर्मी खुद काम नहीं करेगी तो क्या होगा? आर्मी खुद फाइट नहीं करेगी, अगर आर्मी खुद मोटिवेट होके फ्रंट पे लड़ना नहीं जाएगी तो क्या होगा? कितने भी अच्छे आर्म्स हो, कितने भी अच्छे आपके पास आर्मेचर्स हो, आप कोई भी लड़ाई नहीं जीत सकते हो। तो इन शॉर्ट माय पॉइंट इज गवर्नमेंट अपना रोल बाखुदा जानती है, और इसलिए जो 5 साल में हमारा 81 से 46 हुआ है, वो गवर्नमेंट की जो पॉलिसीज थी उनमें काफी चेंजेस, काफी बदलाव लाए। भले आपको शायद काफी चीज मालूम हो या ना हो, बट there are a lot of things which government has done central level, state level, और उसकी वजह से ही ये इनोवेशन, क्योंकि ये देखिए यहाँ कोई भी इन्फ्लुएंस नहीं चलता है, क्योंकि वर्ल्ड लेवल की एजेंसी न्यूट्रली सभी कंट्री का एनालिसिस करती है। तो ऐसा भी नहीं है कि कोई मोदी साहब या कोई इसको इन्फ्लुएंस कर सकता है, ऑफ कोर्स नॉट, बिकॉज उनका ये लेवल जो है GII का वो बहुत बड़ा है। तो न्यूट्रली दे आर एनालाइजिंग एंड देन दे आर गिविंग अस द रैंक, राइट। तो सरकार अपना काम कर रही है, हमें अपना काम करना पड़ेगा, तभी ये लड़ाई जो है नॉलेज इकोनॉमी की हम जीत पाएंगे, और इंडिया को एक टॉप 10 में जो हमारा एक विजन होना चाहिए सबका, उसमें पहुंचा पाएंगे। जो चाइना आई थिंक 12 तक तो पहुंच ही चुका है, ये 2022 के साल में जब सितंबर या अगस्त में पब्लिश होगा, ऑफ कोर्स चाइना में कम इन द टॉप 10 इन द वर्ल्ड, जो एक समय में हमारे साथ ही था, 50 के ऊपर उसका रैंक था, लेकिन धीरे धीरे हम डिग्रेड हो चुके 2010 से 15 में, और उन्होंने कंटिन्यूअसली अपने आप को ग्रूमिंग किया और आगे बढ़ते गए, और आज ये सिचुएशन आई है। ये ग्राफ जो आपके सामने, उसमें एक आपको लेफ्ट साइड पाई चार्ट है, जो एक लाइट ग्रीन कलर दिख रहा है, एक डार्क ग्रीन है। लाइट ग्रीन है दैट इज यू कैन से द नंबर ऑफ इनोवेशन और पेटेंट फाइलिंग बाय द चाइना। डार्क ग्रीन है दैट आर द नंबर ऑफ पेटेंट्स फाइल इन द US। किसका आपको ज्यादा दिख रहा है? लाइट ग्रीन, am I right? That means China has even surpassed the US in terms of the patent filing. Almost China एक साल में, अभी आज की तारीख की बात करें, 8 लाख पेटेंट फाइल कर रहा है। कितनी? 8 लाख। और US में करीबन 6,20,000 पेटेंट फाइल हो रही है, जो लास्ट 2021 का डेटा है उसकी मैं बात करूं। और अगर ये जो पाई चार्ट में आप देखोगे तो आई हैव कंपेयर्ड द ब्रिक्स कंट्री, मींस ब्राजील, रशिया, इंडिया एंड चाइना, एंड ऑफ कोर्स द US इन अ डार्क ग्रीन। इंडिया की बात करें तो इंडिया का इसमें कौन सा कलर होना चाहिए? ये पाई चार्ट में कौन सा कलर हमारा कंट्री का होना चाहिए? सर सबसे छोटा जो कंट्रीब्यूशन है वो हमारा होगा। ऑफ कोर्स यू ऑल आर राइट। हार्डली इन इंडिया वी आर फाइलिंग 48,000 to 50,000 पेटेंट्स इन अ ईयर। चाइना आज 8 लाख पेटेंट फाइल कर रहा है, और इंडिया से हम लोग ओनली 50,000 पेटेंट्स ही फाइल कर रहे हैं। सो दैट इज समथिंग अ बिग अलार्म all of us। अगर दूसरा भी एक आपको मैं एनालिसिस और जो फैक्ट है उसको बताओ, तो अगेन आपको एक बार चार्ट दिखेगा जिसमें यू कैन सी द फर्स्ट बार चार्ट, जिसमें फर्स्ट आपको चाइना दिखेगा बिकॉज चाइनीज नंबर ऑफ पेटेंट्स आर हाईएस्ट, नेक्स्ट इज यूएस। हर एक बार जो है उसमें आपको दो कलर दिखेंगे, एक अपर साइड डार्क ग्रीन है, लोअर साइड लाइट ग्रीन है। डार्क ग्रीन क्या इंडिकेट करता है कि वो पर्टिकुलर कंट्री में कितनी पेटेंट्स है जो फॉरेन कंपनीज या फॉरेन इंडिविजुअल्स ने फाइल की है, और लाइट ग्रीन इंडिकेट्स नंबर ऑफ पेटेंट्स फाइल बाय देयर ओन सिटीजंस। जो चाइना की बात करें, जो 8 लाख में बात करो आज की तारीख में 2021 की, ओनली 20% पेटेंट्स फाइल बाय द एक्सटर्नल्स, मतलब मल्टीनेशनल या फॉरेनर्स। 80% पेटेंट्स फाइल बाय द चाइनीज रिसर्चर्स, चाइनीज कंपनीज, राइट। और उसमें भी 80% में से 50% फाइल बाय द चाइनीज एकेडेमिया, विच इंक्लूड द स्कूल, कॉलेजेस, यूनिवर्सिटीज, जो आप लोग अभी पढ़ रहे हो। वहां के स्कूल्स में भी ये आईपीआर इज अ कंपलसरी, वहां कोई ऑप्शनल सब्जेक्ट नहीं है या इलेक्टिव्स नहीं है कि आप उसको सिलेक्ट करो आईपीआर को, कि भाई हमें कुछ अच्छा लग रहा है इसमें, आईपीआर को एज ऑप्शनल सब्जेक्ट सिलेक्ट करूँ या एज अ सेमिनार में उसका सिलेक्ट करूँ। वहां स्कूल से ही ये आईपीआर पढ़ाया जाता है, कंपलसरी है पढ़ना, राइट। इसलिए आज हम देखेंगे कि चाइना यूएस को भी पीछे छोड़ के टेक्नोलॉजी में आगे निकल चुका है, because they have emphasized more and they have realized that boss, in this decade China cannot become a superpower only beer of, you can say, the manufacturing hub or multitasking hub of the world. We must have to work hard to make a technology hub in China. तो आज उन्होंने वो प्रूव कर दिया और यूएस को भी पीछे छोड़ दिया, जो एक समय का नंबर 1 था। यूएस में अगर आप देखेंगे तो डार्क ग्रीन, लाइट ग्रीन ऑलमोस्ट दोनों एक समान है, 50-50%, मतलब 50% यूएस के सिटीजन है 6,20,000 में से, और 50% बाहर के फॉरेनर्स फाइल कर रहे हैं। इंडिया का ग्राफ आपको दिख रहा होगा, आई थिंक फर्स्ट ग्राफ में लास्ट में से फोर्थ है, उसमें आपको मेजरली डार्क ग्रीन दिखेगा, लाइट ग्रीन बहुत कम है, क्योंकि आउट ऑफ जो 48,000 या 50,000 पेटेंट जो फाइल हो रही है, उसमें से 80% पेटेंट बाहर के लोग इंडिया में फाइल कर रहे हैं। हमारे लोग, मतलब इंडियन कंपनीज की बात करें, आर&डी सेंटर्स की बात करें, सीएसआर लैब्स की बात करें, यूनिवर्सिटी की बात करें, हार्डली 20% ही फाइल हो रही है। मतलब कितना हुआ 50,000 का, अगर आप 20% गिनो, इट इज हार्डली 10,000। कहां चाइना अपने कंट्री की 8 लाख में से 6 लाख पेटेंट फाइल कर रहा है, और कहां हम 10,000 पेटेंट फाइल कर रहे हैं। Of course it is a huge gap, but ये मानना मतलब ऐसा इम्पॉसिबल नहीं है कि हम उससे भी कॉम्पीट नहीं कर सकते, क्योंकि आज देखिए काफी माध्यम से चाइना ने भी ये ओवरनाइट नहीं कर पाए। पिछले 20 साल से, जब 1995 में WTO एग्रीमेंट हुआ वर्ल्ड लेवल का जिनेवा में, उसके बाद चाइना ने समझ लिया था कि बॉस नेक्स्ट वॉर वुड बी द नॉलेज वॉर, और उसमें अगर हमें चाइना को सुपर पावर बनाना है, देन आवर आर्मी जो बॉर्डर पे लड़ रही है उसको तो हमें स्ट्रॉन्ग करना ही पड़ेगा, बट वी मस्ट हैव टू मेक आवर फैकल्टी, स्टूडेंट्स, सॉरी, रिसर्चर, इंडस्ट्री पर्सनल स्ट्रॉन्ग इनफ टू हैव अंडरस्टैंडिंग ऑफ द नॉलेज वेपन्स लाइक पेटेंट, ट्रेडमार्क एटसेट्रा। उन्होंने क्या किया? At a time, they have started 5,000 nodal center across the China. मतलब हर एक डिस्ट्रिक्ट वाइज, हर एक तालुका वाइज आप समझो 5,000, मतलब हर एक तालुका में एक आईपीआर का नोडल सेंटर, और सबको वहां कंपलसरी किया गया है। वहां के नजदीक जो भी एकेडमिक इंस्टीट्यूट है या कॉलेजेस है, यूनिवर्सिटीज है, वहां के फैकल्टीज को वहां पे ट्रेनिंग किया जाएगा, मतलब उनको ट्रेनिंग दी जाएगी विगरसली। देन दैट ट्रेनर्स हैज टू डू द नेक्स्ट लेवल ट्रेनिंग, लाइक ट्रेनर टू ट्रेनर, मतलब वो फील्ड ट्रेनिंग ट्रांसफर करनी है अपने स्कूल्स में, कॉलेजेस में, लाइक सो ऑन। एंड दैट्स व्हाई चाइना हैज मेक आईपीआर एज अ कंपलसरी सब्जेक्ट, क्योंकि सभी को उन्होंने ट्रेनिंग दे दी। टॉप लेवल पे जो भी थे, उनके जो मिडिल लेवल पे थे और बॉटम लेवल पे थे, हर एक लेवल पे उन्होंने कंपलसरी कर दिया, ये ट्रेनिंग लेनी ही है। और वहां ये ऑप्शनल नहीं था। आपको मालूम है चाइना में नथिंग इज ऑप्शनल। इतने बड़े जो जैकमा थे, जो बहुत बड़े बिजनेसमैन है वहां के, उनको भी उन्होंने एक बार साइड लाइन भी कर दिया है, मतलब दे कैन डू एनीथिंग वहां की जो गवर्नमेंट हो। तो ये भी वहां कोई भी ऐसा नहीं है कि भाई नहीं हम ये नहीं पढ़ना चाहते हैं। यहाँ तो आप बोल सकते हो आपके टीचर्स ऑफ फैकल्टी, सर हमें ये सब्जेक्ट नहीं अच्छा लगता है, तो आप दूसरा सब्जेक्ट हमें सजेस्ट किया, दूसरा टॉपिक सजेस्ट किए, बट इट इज नॉट पॉसिबल इन चाइना। बट अगेन यू कैन सी द इम्पैक्ट। वो फोर्स हुआ तभी आज चाइना नंबर 1 पोजीशन पे पहुंच चुका है। बट इन इंडिया वी मस्ट हैव टू वर्क हार्ड, गवर्नमेंट इज ट्राइंग देयर लेवल बेस्ट, और अभी हमारा रोल है, बिकॉज हियर वी आर द सोल्जर्स। ये अगर नॉलेज वर्क की हम बात कर रहे हैं तो यहाँ हमारा रोल एज ए सोल्जर का हमें समझना है। हम बॉर्डर के ऊपर जाके कभी भी लड़ नहीं पाएंगे आप और मैं। हमें यहीं रह के जो घर की लड़ाई है और ये जो नॉलेज वेपन्स का यूज करे लड़ाई लड़नी है, वो हमें ही लड़नी है। मोदी जी या कोई भी गवर्नमेंट आए वो हमें सपोर्ट कर पाएगी, बट अल्टीमेटली वी हैव टू कम फॉरवर्ड टू फाइट। ऑफ कोर्स ये थोड़ा और स्टैटिस्टिक्स है जिसमें इंक्रीमेंटल आपको दिखेगा, चेंजेस हो रहे हैं, बट ग्रेजुअली हो रहे हैं काफी। हमें भी इसमें अपने आप की अवेयरनेस बढ़ानी पड़ेगी और हमें काम करना पड़ेगा, क्योंकि देखिए गवर्नमेंट कितना भी आपको फंडिंग दे दे, लेबोरेटरी ना पे आके गवर्नमेंट काम नहीं कर पाएगी। वहां तो आपको और हमें ही काम करना है, रिसर्च आपको और हमें ही करना है, और पेटेंट आप और हम ही कर पाएंगे। गवर्नमेंट कैन नॉट फाइल पेटेंट बाय देमसेल्व्स। इसलिए आप देखो कि अभी 50,000 तक ही पहुंचे हैं। ऑफ कोर्स ग्रोथ रेट की अगर बात करें उसमें थोड़ा अच्छा फिगर है, बट नंबर्स की बात करें मतलब इन टर्म्स ऑफ ओवरऑल नंबर, तो जो पहले का फिगर था बहुत अभी हमारे लिए शर्मजनक है। हमें और आगे काम बहुत करना है बाकी। तो चाइना अगेन इन टर्म्स ऑफ पेटेंट, ट्रेडमार्क, डिजाइन, उसका ग्रोथ रेट टॉप मोस्ट पे है। इंडिया की बात करें तो अलग अलग है, बट ओवरऑल ग्रोथ रेट इज 8। व्हाट इज द वैल्यू ऑफ ए पेटेंट? पेटेंट की हम बात कर रहे हैं तो उसकी कोई वैल्यू है? ऑफ कोर्स। ये भाई साहब को पूछे, राइट, स्माइलिंग फिगर जिसकी हम आज सभी कंप्यूटर सिस्टम में आई थिंक आज इनका ही हम सिस्टम्स यूज कर रहे हैं, माइक्रोसॉफ्ट ऑफिस सभी के सिस्टम्स में। तो इनको पूछे कि सर क्या वैल्यू हो सकती है, देन ही सिंपली स्माइल कि डॉक्टर मनीष इट मे बी द $1 billion or it may be zero also, right? In his company, though he is not directly now involved with Microsoft, हमारे जो इंडिया के ही अभी सीईओ है वहां पे है, तो ऑलमोस्ट 500 उनके पास पेटेंट एक्सपर्ट है। एवरेज 5,500 पेटेंट्स एक साल में वो लोग फाइल कर रहे हैं। मतलब ऑन एन एवरेज आप देखोगे तो 5 to 10 पेटेंट्स इन अ डे दे आर फाइलिंग। इसलिए आज उनकी वैल्यू या उनकी कंपनी की वैल्यू टॉप 3 में है। इनको पूछे कि सर व्हाट इज द वैल्यू ऑफ पेटेंट, तो आज ये भाई साहब भी आज हमारे साथ अवेलेबल नहीं है। अगर इनोवेशन की बात करें तो ही इज अ पर्सन जो पूरी इनोवेशन की दुनिया में एक रिस्पेक्टेबल नाम है, क्योंकि मोबाइल टेक्नोलॉजी को पूरा ही नेक्स्ट लेवल पे ले जाने का काम ये भाई साहब ने किया। उनकी कंपनी को तो वो टॉप मोस्ट लेवल पे ले ही गए थे ये भाई साहब, बट उनके खुद के नाम पे भी 313 पेटेंट्स थी। और उसकी वजह से जब उनका देहांत हुआ, हिज नेक्स्ट जनरेशन मतलब उनके जो वाइफ और उनके सन और डॉटर थे, उनको ऑलमोस्ट हर एक साल के लिए जो रेवेन्यू मिल रही थी, क्योंकि एज वी नो के नाउ पेटेंट लाइफ इज ऑफ 20 इयर्स, तो उनको एटलीस्ट नेक्स्ट 20 इयर्स तक का उनको जो रॉयल्टी थी, जो एक साल में करीबन $10 मिलियन मिल रही थी, वो मिलेगी। मतलब उनके सन डॉटर या वाइफ कुछ काम करे या ना करे, एक साल में उनको $10 मिलियन रेवेन्यू इज फिक्स्ड थ्रू द रॉयल्टी ऑफ पेटेंट ओनली। सो दैट मीन्स ही हैज यूज्ड पेटेंट एज अ टूल, एज एन इन्वेस्टमेंट। जब हम यहाँ की बात करें, हम LIC, म्यूचुअल फंड वगैरह में इन्वेस्ट करते हैं, तो ये इन जैसे भाई साहब पेटेंट में इन्वेस्ट करते हैं। ऑफ कोर्स पेटेंट के काफी लीगल केसेस भी है। एप्पल वर्सेस सैमसंग, इट वाज वेरी रिमार्केबल केस हैपेंड फ्यू इयर्स बैक, जहां एप्पल ने सैमसंग के साथ फाइट की। अल्टीमेटली एप्पल वन द केस, सैमसंग हैज टू पे $1.05 billion plus $707 million, ऑलमोस्ट अप्रोक्सीमेटली $2 billion सैमसंग को पे करने पड़े एप्पल को। अभी कोविड की हम बात करें तो सिंस लास्ट 2 years वी आर फेसिंग द चैलेंजिंग सिचुएशन ऑफ कोविड की वैक्सीन की अगर हम बात करें तो फाइजर वाज द फर्स्ट जो वैक्सीन को लेके आया मार्केट में। ऑफ कोर्स उनकी वैक्सीन इंडिया में अभी तक नहीं उनकी सैंक्शन हो पाई है, बट काफी उसके मल्टीपल रीजंस है टॉप लेवल पे। बट इफ वी कैन सी their product is costly than our like Indian vaccine manufacturers. One of the reason because they have some patented technology which they have used in their vaccine production. इसलिए उनका जो पेटेंट का जो है you can see 15.50 pound per dose उनको पे करना है यूरोपियन यूनियन को सिर्फ ये एक डोज के लिए, मतलब यू कैन इमेजिन बहुत बड़ा इनका वॉल्यूम उनको ऑर्डर करना पड़ता है यूरोप में, क्योंकि उनके पास भी खुद अपनी इन हाउस टेक्नोलॉजी इतनी सारी नहीं थी कि पूरे यूरोप को दे पाए, तो इनसे उनको खरीदना पड़ा. But South Africa and India is continuously pushing to have a, you can say, the stop the patent rights at least on the COVID-19 vaccine and other products. क्योंकि COVID-19 is a global situation. अगर हम यहाँ एक या दो या तीन कंपनी का मॉनिटरी बेनिफिट देखे जाए पेटेंट के माध्यम से, तो सही नहीं होगा. यहाँ हमें जनरलाइज्ड एक होलिस्टिक व्यू जो इंडिया का आज तक का रहा है कि वी ऑलवेज सी कि द citizen of our country and of course the citizen of the world and their health is our first priority, what we say in Sanskrit vasudhaiva kutumbakam. तो ये फिलोसॉफी को हम सालों से मानते आए, इसलिए इंडिया का बहुत स्ट्रॉन्ग इसमें परसुएशन है वाइपो में, WTO में, और अभी आई थिंक ये मार्च में ही एक वहाँ हाई लेवल की मीटिंग होने वाली है. और अभी WTO के जो टॉप मोस्ट जनरल सेक्रेटरी थे वो लास्ट मंथ हमारे मिनिस्टर को मिलके गए दिल्ली में, एंड दे अंडरस्टूड अवर व्यू पॉइंट. बोस आप क्या कहना चाह रहे हो, किस तरह इंडिया का इसमें पॉइंट है इन टर्म्स ऑफ यू कैन से द पेटेंट स्टॉपेज फॉर द कोविड-19 वैक्सीन एज वेल एज द कोविड-19 अदर प्रोडक्ट्स आल्सो. तो लेट्स होप, क्योंकि आज पूरा वर्ल्ड इंडिया की तरफ देख रहा है, बिकॉज इंडिया हैज टू प्ले अ मेजर रोल इन द वर्ल्ड इकोनॉमी. तो दैट्स व्हाई वाइपो जनरल सेक्रेटरी इज आल्सो कमिंग डाउन टू इंडिया. वो भी काफी सालों के बाद फर्स्ट टाइम वो इंडिया में आए हैं, तो वो भी एक रिमार्केबल है कि दे वुड लाइक टू अंडरस्टैंड आवर यू कैन से फिलोसॉफी, आवर व्यू पॉइंट. नेक्स्ट अगर बात करें, हैदराबाद में एक नाटको फार्मा है, उन्होंने ऑलरेडी एक कंपल्सरी लाइसेंस के लिए फाइल कर दिया है. बेरिडसिटिनिब, इट इज अ बायोलॉजिकल डिराइव्ड प्रोडक्ट फ्रॉम द इली लिली कंपनी, जिनका इनके ऊपर पेटेंट है. एंड अगेन इट इज यू कैन से रीपर्पस्ड ड्रग फॉर द कोविड-19. पेटेंट होने के कारण काफी लोगों को मालूम है, जब कोविड का आई थिंक फर्स्ट वेव सेकंड वेव था, थर्ड वेव में इतनी सारी जरूरत नहीं पड़ी थी, बट ड्यूरिंग फर्स्ट एंड सेकंड वेव मेनी पीपल हु आर द सीवियरली इल, उनको मोनोक्लोनल एंटीबॉडीज के इंजेक्शन देने पड़ रहे थे. और काफी टाइम ऐसा होता कि इंजेक्शंस की अवेलेबिलिटी नहीं हो रही थी, उसके लिए पेशेंट्स डाई हो रहे थे, या इंजेक्शन अवेलेबल थे बट ब्लैक मार्केट में थे, जो इंजेक्शन की 10,000 वैल्यू 1-1 लाख 2-2 लाख में मिल रहे थे, राइट. And again, lot of scams have been identified by the regulators also कि काफी डुप्लीकेट भी मार्केट में इंजेक्शंस आ रहे थे ड्यू टू दिस स्कैरसिटी. इसीलिए नाटको फार्मा ने आगे चल के कंपल्सरी लाइसेंस के लिए फाइल किया है. लेट्स होप उनको अगर कंपल्सरी लाइसेंस का मिल गया इन द ड्यू कोर्स ऑफ टाइम, और इंडियन कंपनी विल आल्सो कम आउट विद दिस मोनोक्लोनल एंटीबॉडी प्रोडक्ट. Of course, in India we always believe to convert the challenge to opportunity. Somebody has developed umbrella to helmets that fight the COVID-19. थोड़ा सरप्राइजिंग आइडिया है, बट अगर आप देखोगे गूगल में तो आपको इसका डिटेल मिलेगा कि हाउ अम्ब्रेलास टू हेलमेट्स अलग अलग माध्यम से हम कोविड-19 को फाइट कर सकते हैं, राइट. अगेन गुजरात की बात करें, गुजरात भी कहीं पीछे नहीं है इनोवेशन के माध्यम में. ये भी थोड़ा इंटरेस्टिंग इनोवेशन आपके सामने मैं जैसे कि एग्जांपल देना चाहूंगा. लेफ्ट साइड में आप देखोगे आयुर्वेदिक रेस्पिरेटर N95 मास्क. आप सभी को भी N95 मुझे क्या बताने की आवश्यकता नहीं है कि व्हाट इंपॉर्टेंट रोल N95 हैज पुट फॉरवर्ड सिंस लास्ट 2 इयर्स. उसके पहले आई थिंक किसी को मालूम नहीं था कि N95 जैसे मास्क की कोई एग्जिस्टेंस है, बट आज की तारीख में बच्चा जानता है कि N95 मास्क क्या है. बट अगर ये देखें गुजरात का इनोवेशन, तो हमने उसका भी एक आयुर्वेदिकरण कर दिया है. उसमें भी हम लोकल लेवल पे एक अच्छा आविष्कार किसी ने किया है. ऑफ कोर्स हाउ स्ट्रॉन्ग द क्लेम इज दैट नीड टू बी चेक, बट ऐसी प्रोडक्ट ऑलरेडी आपको भी देखने को मिलेगी जहां 50 रुपए में आयुर्वेदिक N95 भी आपको मिलेगा. सो इट इज ऑल्सो आई कैन से काइंड ऑफ वी कैन से इनोवेशन, एंड वी ट्राई टू कन्वर्ट द चैलेंज टू द अपॉर्चुनिटी. Last but not the least, I would like to summarize my talk by saying that innovation is a journey from mind to market and concept to commercialization, and we must have to follow the principle of 3P. That means initially we must have to think about patent, then automatically publication will happen, and then after automatically prosperity will come. So finally, from where we have started with the equation 3I, अगर हम 3I का उपयोग करेंगे हमारे कोई भी आविष्कार या इन्वेंशन में, उसके साथ में अगर हम 3P के एलिमेंट्स को भी जोड़ेंगे, तो ऑफ कोर्स इट इज ऑलमोस्ट श्योर दैट कि यू विल गेट 3M, जहां हमने मोरल राइट्स की बात की, मोनोपोली राइट्स की बात की, एंड ऑफ कोर्स लास्ट वेरी इंपॉर्टेंट मॉनिटरी राइट्स की भी बात की है. So we can say IPR can act as a catalyst to convert research to revenue from Mother Saraswati to get a blessings of Mother Lakshmi. If you are interested, IPR can able to act as a catalyst in this entire process. Thank you to one and all.
Thank you so much, sir, for sharing your reflective knowledge with us. Sir, we are having few questions.
Okay.
I'm going through it. Sir, participant have one question, that is there any geographical site in Gujarat?
Yeah, a lot of geographical indication, what I understood from his question. So, as of now in India, almost we have 320 plus geographical indication. अगर गुजरात की बात करें तो गुजरात का जो केसर मैंगो है, गिर केसर मैंगो, जो अभी आने का स्टार्ट हो जाएगा तो एक महीने के बाद in the month of May or June, that is also already got you can say the GI right. फिर कच्छी शाल आती है, that already got a GI rights. Right, already the वलसाड़ में भी जो अभी हाफूज होती है, रत्नागिरी हाफूज इज आल्सो फेमस, तो वहां तो ऑलरेडी रत्नागिरी एरिया जो कोंकण एरिया है उनको तो मिला ही हुआ है. सिमिलर वे हमारे जो साउथ गुजरात के फार्मर्स है उन्होंने भी एक एसोसिएशन अभी बनाया है और उन्होंने भी जीआई रजिस्टर को अप्लाई किया है, जीआई राइट्स ऑन वलसाड़ी हाफूज. तो फिर गुजरात में दूसरी बात करें तो अपना ये कच्ची शाल की मैंने बात की, हैंडीक्राफ्ट्स की बात की कच्ची शाल की, फिर पाटन पटोड़ा है, फिर नागपुर ऑरेंज है, फिर आगरे का पेथा है, कश्मीरी पश्मीना है. सो ऑलमोस्ट काफी आइटम्स जो हम समझ सकते हैं कि नाम से रतलामी सेव, राइट, जो भी हम अच्छी चीज समझ पाते हैं वो सभी चीजों में जीआई राइट्स लोग ले रहे हैं. राजकोट की बात करें जहां से मैं बिलोंग करता हूं, राजकोट पेंडा, उनका भी अभी उन्होंने एसोसिएशन बनाया है, तो राजकोट पेंडा विल आल्सो गेट अ जीआई राइट. आप भी आपके रीजन में देखिए कि आनंद का क्या फेमस है. इफ यू कैन थिंक अबाउट इट, यू कैन मोटिवेट योर मैन्युफैक्चरर्स इन योर एरिया, तो दे कैन आल्सो गेट बेनिफिट. उससे क्या एक एडवांटेज होता है कि कोई भी दूसरे लोग उसका मिसयूज नहीं कर पाएंगे. वंस द जीआई राइट हैज बीन गिवन, इट इज नॉट अ राइट गिवन टू इंडिविजुअल. कोई एक कंपनी को, एक आदमी को नहीं मिलता, वो पूरे क्लस्टर को मिलता है. जैसे मैंने बोला गिर केसर मैंगो, तो गिर रीजन के जितने भी मैंगो फार्म्स या फार्मर्स है, they can sell their product as a गिर केसर मैंगो. अभी वही मैंगो है, मतलब केसर मैंगो ही है, वो वलसाड़ से भी आती थी, साउथ इंडिया से भी आती थी, बट नोबडी कैन राइट गिर केसर मैंगो. ओनली तो गिर रीजन के जो फार्मर्स है वही लिख सकते हैं कि गिर केसर मैंगो. अगर आपको ऑथेंटिकेट टेस्ट खाना है, यू मस्ट हैव टू सी इट शुड बी हैविंग अ गिर केसर मैंगो. केसर मैंगो कोई भी बेच सकता है, बट गिर केसर मैंगो ओनली द फार्मर्स फ्रॉम दिस गिर रीजन कैन एबल टू manufacture and they can be able to sell in the market.
Thank you, sir. Sir, one more question is that if one discover a new formulation for your plant by mentioning particular geographical area, is this work is patentable or not?
तो यहाँ आई थिंक दो चीज उन्होंने क्लब की. एक जियोग्राफिकल एरिया की बात कर रहे हैं, तो जियोग्राफिकल एरिया एज आई डिस्कस विद दिस एग्जांपल, इट कैन नॉट बी गिवन टू इंडिविजुअल, नंबर 1. तो आई थिंक दैट इज नाउ क्लियर. नाउ सेकंड का क्वेश्चन था कि कोई हमने हर्बल प्लांट लिया, उसका कोई फॉर्मुलेशन बनाया, तो उसका पेटेंट हो सकता है कि नहीं? आंसर इज यस. क्या पेटेंट हो सकता है? देखिए, कोई भी नेचुरल चीज जो आप नेचर में से लेते हो उसकी पेटेंट नहीं मिल सकती है. आप उसका एक्सट्रैक्ट बनाते हो, उसकी आपकी जो प्रोसेस है एक्सट्रैक्शन की, उसकी पेटेंट हो सकती है. दैट इज नॉट अ प्रोसेस पेटेंट. आप उसको अलग अलग 5 या 6 एक्सट्रैक्ट्स को एक यूनिक फॉर्म में, उसके एक यूनिक कंपोजिशन में मिक्स की कोई एक इफेक्ट जो भी डिजीज के लिए आप उसको क्लेम करना चाहो, अगर आप बनाते हो, देन यू कैन एबल टू गेट अ फॉर्मुलेशन पेटेंट, राइट. अगर वो तब से बनाई गई है, अगेन इट इज नॉट एबल टू गेट अ पेटेंट, क्योंकि अगेन वी हैव नॉन पेटेंटेबल क्लोज अंडर सेक्शन 3P, जिसको हम ट्रेडिशनल नॉलेज बोलते हैं. सो एंटायर आयुर्वेदा कम्स अंडर द, आपका ट्रेडिशनल नहीं होना चाहिए, क्लासिकल नहीं होना चाहिए. इट शुड बी ऑन अ डेवलप ऑन अ मॉडर्न कंसेप्ट, नंबर 1. Second, you have to combine them in a proper, you can say, proposition, and you have to prove that it is acting as a synergistic. जैसे मैंने बोला कि अगर a plus b या ये केस में a plus b plus c plus d अगर करते हैं, if it is a mean, again you will not get it, but you must have to prove that they are acting synergistically. मतलब 1 plus 1 should be greater than 2. अगर ये आप प्रूव कर पाते हो आपके एक्सपेरिमेंट या रिसर्च से, तो ऑप्शन पैटर्न मिल सकती है. बट आपको इंडिविजुअल पेटेंट या इंडिविजुअल एक्सट्रैक्ट या उसके कोई भी केमिकल कंस्टिट्यूएंट की पेटेंट नहीं मिल सकती है, क्योंकि नेचर ने उसको बनाया है. आपने किया, उसमें इंटरवेंशन किया, आपने वो प्रोसेस आपने आइडेंटिफाई की, आपने उसका अलग अलग प्रोपोजिशन में उसको मिक्स किया, 20%, 10%, 30%, वो आपका इंटरवेंशन था, आपको उसकी पेटेंट मिलेगी. आपने उसकी टैबलेट बनाई, कैप्सूल बनाई, उसकी पेटेंट आपको मिलेगी. आई होप आई एम क्लियर टू यू एज वेल एज द.
Yes, definitely.
Yeah.
Once again, I want to thank you, sir. And as a token of gratitude, I would like to present us.
Thank you.
So this is some appreciation, sir, for you.
Thank you very much. And I wish what I said, utilize this platform जो आज आपकी कॉलेज ने आप सबको प्रोवाइड किया है, not only to say mere day, one day workshop and having a certificate at the end. उससे आप कंफ्यूज मत करिएगा, क्योंकि war in knowledge front already has been begun. बिगल इसका तो काफी टाइम से बच चुका है, हमें सुनाई में नहीं दे रहा है, वो बात अलग है. लेकिन आज मैंने थोड़ी कोशिश की कि आपको थोड़ा इसका अंदाजा हो. आप भी ट्राई कीजिए, आप लेवल जो लेवल पे फैकल्टी या स्टूडेंट्स कुछ ना कुछ अच्छा करे और आगे बढ़े. That is what I wish, and wish to best wishes to all of you.
Thank you so much, sir. Once again.
Thank you, sir. And near future, they should have some patent on their name.
I will always pleasure to see that, madam. At least we have to try basically. देखिए, अगर पेटेंट आप आज की तारीख में आई थी, तो दूसरे एक्सपर्ट आपको समझाएंगे कि पेटेंट की आज की तारीख में फीस भी गवर्नमेंट ने बहुत कम रखी है, बहुत नॉमिनल फीस है. एंटायर पेटेंट की प्रोसेस की बात करें तो 6,000 7,000 में आपकी पेटेंट फाइल होती है. आपके पूरे महीने का पॉकेट मनी भी इससे ज्यादा होगा आज की तारीख में. उससे कम दाम में आप एक पेटेंट फाइल करते हैं. और अभी जो पहले का सिचुएशन था, उसमें तो मैडम 6 साल 7 साल हमें वेट करना पड़ता था एग्जामिनेशन होके रिपोर्ट आने में. आज गवर्नमेंट का ये फोकस है, इसलिए ये जो चेंजेस मैंने आपको थोड़ा हाईलाइट की तारीख में पेटेंट हो सकता है कि 1 साल के अंदर भी एग्जामिनेशन के ग्रांट भी होती है. कल ही मेरे एक फ्रेंड से मुझे शेयर किया कि 7 मंथ्स जो आज की तारीख में हिस्ट्री में होगा कि 7 मंथ्स में एक हमारे गुजरात के ही एक ग्रुप ऑफ स्टूडेंट्स थे, उनकी पेटेंट ग्रांट होके 7 मंथ्स में आ गई उनके पास. सो गवर्नमेंट इज आल्सो वेरी कीन नाउ, क्योंकि देखिए उनका काम है सपोर्ट करना, वो कर रहे हैं. जो प्रोसेस थी लेंदी थी, उन्होंने कट शॉर्ट किया. 6 साल 5 साल 4 साल 2 साल लेवल से काम, काफी लोगों को इन्वॉल्व नहीं कर रहे हैं, टॉप लेवल से बॉटम लेवल तक.
हमारा काम रिसर्च करना,
अप्लाई करना, राइट. सो लेट्स डू दैट.
Okay, thank you, sir.
Thank you, sir. Now moving on towards our next panel session, we have with us Dr. Prachi, Deputy Director, Center of Startup and Entrepreneurship, Patent Agent, and Associate Professor, Krishna Skula. She would be delivering a talk on filing of patent application and the case studies. I request Dr. Aliasgar Kundawala, HOD of Pharmaceutics Department. I request Dr. Prachi Pandey. Over to you.
Thank you, Anita. Good afternoon to everybody. Invited dignitaries, my fellow colleagues, dear participants. This is Dr. Ali Kundawala, from Associate Professor and Head of Department of Pharmaceutics and Pharmaceutics. Today we have a great speaker present among us to deliberate with the patent filing application. Dear friends, patent is important because it can help invention. It can protect your product design or the process that meets certain specifications according to its originality, practicality, and utility. To protect intellectual property rights of inventor must apply for the patent and to give you insight into patent filing, very good speaker, Dr. Prachi Pandey. It is my pleasure to introduce our speaker, Dr. Prachi, is Deputy Director, Krishna Center of Startup from KPGU, Vadodara. Has 14 years of experience in research. She has in pharmacy and completed her postgraduate diploma course from National Academy of Legal Studies and Research, Hyderabad. First rank in India with A++ grade. She is registered patent agent of Indian Patent Office. Currently, she is also pursuing her MBA in finance. Received a research grant of 14.5 lakhs under the research promotion scheme of AICTE New Delhi for her core research, and 7.8 lakhs as a mentor under the different scheme of SSIP. She has received appreciation award for getting shortlisted among top inventors and entrepreneurs of India through the event organized by AICTE, DST, Government of India, and CII held at IIT New Delhi. Received Innovate to Impact Award twice from the GQ Innovation Council for outstanding research 2 years. She has received National CEGR Young Scientist Award in year 2019. She has filed and prosecuted 35 in India Patent Office. She has published 24 research papers and authored 5 chapters in the reputed publishers like John Wiley, USA, and Spingerling. She has attended and presented papers in more than 50 national and international conferences along with IP capacity building program at Indian Institute of Management, Bangalore. She has also been impaneled as the legal and startup counselor in startup clinical program of SSIP Gujarat. Also the innovation ambassador of Ministry of Education Innovation Cell of AICTE and president of Indian Innovation Council. She is also known for the implementation of MHRD's National Innovation and Startup Policy for students and faculty. She has delivered 2 expert lectures and patent laws in startup Sathi series of iHub, SSIP Government of Gujarat, along with the 27 lectures on patent, trademarks, copyrights for Technical Institution of India. She has also delivered expert sessions on MHRD, TEQIP programs and in events organized by University of Hyderabad, NDP, IIT. I once again welcome Madam and request her to deliver a talk on filing of patent application and case studies. Over to you, Madam.
Thank you,
Thank you
sir.
very much, sir. Is it audible perfectly?
Yes, ma'am, you are perfectly audible.
Thank you very much to Aliasgar sir for introduction. Thank you very much to Harshimal sir, Usman sir for arranging such useful programs for students and also giving me opportunity to interact with all of you. Thank you. So yes. So today we will learn together about how to do the patent filing and how to prosecute the patents and what are the case studies, something related to pharma patents, to pharma domain and also the patent. This is my favorite field and I really enjoy giving you some knowledge. If you have any question, you can ask me in between also. So we should have an interactive search. Together we can also prepare for filing of our patent applications. So I'm sharing my screen with all of you. Is it visible?
Yes, ma'am, visible.
Okay. So first of all, I would like to highlight some of the advantages, benefits of India as per Startup India Initiative 2016. First of all, 80% rebate on filing fees. So every natural person, startups, and even educational organizations can file a patent at a 80% reduced 1,500 as compared to companies who are paying more than 8,000. Now at 1,600, we can file a provisional as well as a company. And yes, normally the normal time for publication of a patent application is 18 months from the provisional filing date, that is filing date. But if we want to do it through expedited process, we can avail the benefit by filling the Form 9 by paying a fee of 2,500 only. Also, there is a facility of expedited examination process within 105 days. So suppose today we have filed a patent application and we have also gone through an expedited publication by filling the Form 9. Within 1 month, application is published on the site of Patent Office and included in the Journal of Patent. So after publication, we can apply for examination. And examination can take place through expedited examination process if we fill A and can pay a fee of 8,000. Normal examinations, for that we have to submit the Form 18 and have to pay a fee of 4,000. That normally takes about 1 year to 2 years. Through expedited examination process, we can avail the benefit and can get it completed within 105 days. Means like just about 3 months. So in 4 months, the examination report could be generated. So if we are ready with our product and can answer the queries raised in the first examination report within 1 month, even in 5 to 6 months, we can get our patent grant. But important is that if we are very sure about our product and we have all the data, the lab manuals, all the raw data, but that is important to somewhere prove our novelty and usefulness, then we can go through an expedited process. If we also need some time, I just suggest for the innovators, especially academicians, normal procedures. Because normally we also take some time in answering to the queries raised by the patent office. So these are facilities given, and yes, there is one more facility. Like somewhere we feel that before the application, during prosecution state, that I'm not able to, or I'm not still cannot like answer all the objections raised by the examiner of the case, I can even take back my patent application, and there is a provision of 90% refund for application withdrawals. But this is for natural persons, small entities, and also the educational organizations that is included in the recent amendments.
Sorry to interrupt, Prachi ma'am. Ma'am, can we move to the...
Yeah, okay, just a minute. I think and what's the slide show? Oh, thank you for the information, ma'am. Is it now full screen? It's fine, ma'am.
Yes, ma'am. Thank you, ma'am.
Okay, fine. So 90% refund for application withdrawals is possible. And yes, the last one is not for patent, but there is a tax exemption for 3 years once a company is established. So these are some benefits provided by the government of India warned that we should go for patent filing, patent granted. And I want to let you know, not like early days when there were a lot of objections. Now even patent office want granted. So they can call you for hearing, they will listen to you. Even if you are not a legal person, you can speak in totally technical language to them and they entertain you. This is like they also want that your patent should be granted. So we should take the benefit and leverage all those facilities. Now types of patent application that usually we file as a provisional and complete specification. Beside that, there is a divisional application, additional application, brief highlight of that. Suppose sometimes we incorporate many innovations in a single patent application. So somewhere we feel, or somewhere the controller of patent may object that this is not a unit. There are many inventions reported in a single patent application. They can direct the applicant patent applications into as many the number of innovations, separate patent applications. Yes, the reference number would be there. You will have your priority to divide your patent applications into number of innovations and file them separately with separate fees. So these are divisional applications. Patent of addition is a very good benefit given by the patent office, where before grant or even after grant, if an applicant feels that they have come to an improved version of their already filed patent application, and now it is grant request for addition of filing of patent of addition. So here they will add the extra features, but they cannot boundary of their innovation. After adding extra features, because they are making some improvement, this will be accepted by patent office. Patent will be the same as the main invention. So this patent of addition will expire along with the main patent application, because the improved features must not be hidden with the world. It should be added in the addendum in the main patent application. This is a very good facility. Conventions, these are foreign applications where we file in all countries simultaneously and claimed as the international application date filed in any one of the countries as receiving office, or we can go to the site of WIPO. So here the treaty says that we can claim simultaneously in all the countries, because what happens, suppose I'm doing an innovation in India and somewhere else in some other country, somebody's doing the same innovation. Then because ideas may come and everybody is think in the same direction, they may file a similar kind of patent in their own country. The world will know that who is the true and first inventor. So in that case, there is a system of international application filing, international application on the site of WIPO, or in the Indian Patent Office, because IPO is also an international applications. So this application become our worldwide patent, and we can claim the patent rights all over the world, because now in the era of internet, everything is well connected. And yes, here also I wish to let you know that patent is a territory, because once we get the rights in India, we can market in India only. But while granting of the patent during examination, the exam just go through the World Wide Web and find out that your innovation must not be reported earlier before filing the patent application. So if it is reported in US or public domain, so your novelty will be destroyed. So for granting the patent, important is that you should be novel. Novel means new on the date of filing the patent. So if you have done any publication, if you have like a paper or in any conference proceedings, then it will be in public domain, or suppose it has been used publicly. So these are the grounds on which the patents are rejected. So I always innovators and students basically that if they have some idea in their mind and they're sure that they are able to file application, they can go for the first to file system and can file a provisional application. And they have to complete their production till 12 months. And before expiry of 12 months, they can file a complete specification. And in complete specification, they have to include everything about the findings, the total best mode through which they prepared the product. So all details about the innovation. So it could be done within 12 months. One more thing I wish to let you know, because many times students say that if I'm not able to complete my experimentation within 12 months, then what will happen? So patent office will keep it as deemed to be abandoned, but it is not. You can post-date it for next 12 months. And the date of filing of complete specification will become the date of filing of provisional, and you will get 12 more months to complete your experimentation. But you will be lagged behind by a few months as long as you take in filing your complete. And suppose in between somebody else is doing it, so that will be kind for you. But yes, the first thing is in India is like personal patent application to keep our patent secured. So once we reach the patent office and get a priority number, priority date, after that we can go and publish our papers. We can go and present our papers. There is no harm. Our novelty will never be destroyed. It will never affect our patent application. So, and suppose if in case of any dispute, the person, the patentee would be the person or the rights of patent persons who have filed first. That is the point. And what should an inventor? Why should an inventor file a provisional patent application? Because they get a 12 months buffer time of pendency and do the experimentation. And they can also do some market research. They can add some or incorporate some of the findings. They can improve the features and can come out within 12 months and file the complete specification in which they can include the claims. In complete specification, they have to include the claims, that is what we are claiming. It should not go beyond the boundary of our provisional patent application. So in provisional, whenever we file a provisional, first we have to define the scope of invention. We have to draw a boundary. Suppose if we are a pharma person, we are preparing, just for example, the sustained release tablet, then we have to which class of polymers we are going to take. What would be our aim to achieve? So under that we can do it. Suppose if we are writing some class of polymers, we can choose any polymer in between, but we cannot go for any other component that we have not mentioned in our. So in provisional, we can draw our rough claims. We can draft rough claims, and because if we go beyond the boundary of our objection by the patent office. So for that rough set of claims should be designed, and we have to be sure that we are able to complete within 12 months. Otherwise, we have to post it. Now, what are the documents? Actually, I'm giving it a very basic level so that it should be known to everybody and they can file their patent application by themselves. So first is Form 1. I think many of you have already filed a patent. So this is application for grant of patent, that is including the basic detail of an applicant like name, address, some declarations, title of inventions. Then comes the provisional specification in Form 2. Whenever we are filing a provisional, it will be a provisional application. Form 5. Form 5 is a form whenever applicants are different. Somewhere applicant is our organization because we are filing through organization from our college, and inventors are like 4 of our friends. If applicant has to declare by filling the Form 5 and declare that these are the true and first inventors of this patent application. So Form 5 is mandatory in that case. Suppose inventors and applicants are the same. We 4 friends are the applicants and also the inventors. There is no need to file the Form 5. Form 26 is the power of attorney. Whenever we give power to a patent agent or attorney, e-filing fees is the statutory fee, that is 1600 while filing a provisional application. And Form 3 is also mandatory. Form 1, 2 and 3 are the mandatory forms that should be filed along with a provisional patent application. What is Form 3? Form 3 is a declaration that we have to submit to Indian Patent Office, declaring that we have not filed this patent application outside India. We will keep IPO informed about it. So if suppose we think of filing in any foreign country, first we have to take the permission from Indian Patent Office, and once permission comes in the Form 3, then only we can enter in any foreign country. So suppose if our invention must not go outside the boundary of India, Patent Office may object. If it is a general innovation, then Patent Office may grant us, and then we can enter. So entering in foreign country is best by PCT route, Patent Cooperation Treaty. Why I am telling you? Because normally students say me filing a foreign application a bit very expensive. I tell them India is a developing country, and under that, India is can avail the benefit of action in the fees of PCT through WIPO. So whenever the fees are given as $2,500, you have to just calculate the 90% after reduction of whatever the amount remains. So it is very less. So if we go through the PCT route, through WIPO route, the time is normally 30 months to enter stage, but the fees are very less. It is an official route. You can say that it's through the government we are going through, World Industrialization, and through that route we can get our patent published, can go for a preliminary examination also, and can be very sure about our patent before entering the national phase after 30 months. So this is an important thing that I wanted to mention, that India and all the even the least developed countries still in the category of 90% reduction. So we should avail the benefit of that. Then whenever we in pharma also nowadays, we include drawings, some illustrations. So So those drawings have to be labeled, and labels, suppose we are labeling some part with number 1 or number 2, we have to elaborate what is number 1, what is number 2, and also in our description, we have to mention those numbers. Means we have to cite as a reference. Suppose if we are talking about something and mentioning that component, we can mention in bracket number 1 or number 2, so that people can see the drawing and can get a better idea how it works. So these are the things. Now I'm telling you the basic steps of patent filing. This is not a step of, this is a very important step of patent filing. Whenever we think of filing a patent, how we should go. So first step is idea incubation phase. So as we are all academician and faculty members, it's our duty to tell the students exactly for a patent filing, what to be considered and how we can plan so that our patent should be granted, not just filed. So first of all, we should ask some questions from ourselves, especially for the students. What is my idea? What is my invention? Does it work? And what problem I'm going to solve? Is the problem really solved earlier? Or I'm going to solve something that is not solved? And if I'm solving it, how much long jump I'm taking? Means if something is reported and we are making almost similar to the filing a patent office may object and say that this is very obvious invention. Falling under the criteria of obviousness is a ground of rejection. So being non-obvious means we should incorporate a lot of innovative solution. We should add technical advancements to prove that human intervention is involved, and so that patent office could be convinced about our product. So my advantages are not just very obvious advantages, but if I am a good product in presence of my competitors, then I am better than those competitors. So I should draw some charts. I have to explain in a very better way. And I want to tell you one thing, is like whenever we think of an idea, we should make a proper and write down every pros and cons of that idea, where it will work. If it is like a very applied research, and after getting the patent, if there is a chance of commercialization of that. So what are the chance of IP commercialization? People ask. So if we don't have money, so much of seed fund to open our own premise, normally all students may not have, but we can license our formula to some other firm. We can share in return, we can get the royalty. That is also a big sum. Or even the company can give employment to those students who have a very good patent in their hand. So that will be a kind of students can generate for themselves only and can become self-dependent. So that is a way they can do. So, but how they will, your product is better than the competitor's product. So for a good patent search and find out what are the loopholes. So whenever we map a certain patent application, so normally we go for a synonym search, keyword search, key string search, freedom to operate, all those things we apply, and we find out to take what we are thinking of. So we have to map them. Claim mapping is very important. Whenever we go through the claim, we have to write down separately what process, what findings, and what is the things that is left behind. What are the loopholes? And to cater the loopholes, what is our planning? If we can really do something good and can do a long jump, the simple thing is that we have to go far away from what is reported. If it is there, we should go for filing a patent application and get it published. It will be granted definitely, because patent is granted only on 3 grounds: that it should be novel, not reported, that you can assure by filing your patent application first of all in Indian Patent Office, in non-obvious. Non-obviousness definitely, along with mentor, by doing some brainstorming, we can come out to incorporate in the already existing invention and can make a good innovation. Suppose if patentability option is negative, it can save a lot of cost and time that could have unnecessarily invested in proceedings in the patent filing process, and somewhere the application is rejected later on. So but somewhere if patent filing is for academic purpose, then it's fine to do. But if somebody wants to get a grant, they should start the preparation before they think about the project. So during project screening, if we want to get it, commercialize it, we have to go through such steps. So, and novelty, none of this is industrial application at lab scale. We can reproducibility study that we all do. Is like every time it is giving me the same quality output. And once it is made or used in industry, it can give the same product without any batch variations, intraday variations that we all know. Industrial application is best on that. But like during first examinations, patent office doesn't concentrate on those things. It is very much concentrated on novelty and non-obviousness, because I have received all the queries from patent office as a first examination report, mostly on the novelty. And yes, you will never believe, they will cite review papers and say that you are similar to them. It is very easy to answer, because you can say that these are review papers and yeah, terms are matching, but this is a research I have done, these are my findings. If they cite some patents in their first examination, a little bit difficult, because we have to go and dive inside that patent, again map it. We have to make a table with 2 columns. One is the already patent office is raising objection in that background, and another column is our own patent application, how we are different. We have to map it thoroughly, and through which we can answer. So if some of you have answered or received the first examination report, helpful for you how to answer the queries. Patent drafting is very important, because in description of patent also what are the contents of a patent application, because this is actually needed by students. You have to disclose is for women innovators if they are not a startup. Natural persons and organizations are also included. So through college also, patent could be filed. But the fee is little doubled. You can say it is 8,000. For industries, it is about 60,000. That is very high. So now, once we file the request for examination, then patent office examine our patent application. And majority, almost 90% of applications will receive the objections. That is a protocol. So if somebody might have received like first examination report and you are seeing lot of objections raised, never be panic about it. It's a very general procedure. Even a lot many hearings calls are coming, never be panic about it, because we have to justify, and patent office want that we should justify. So they're giving us opportunities, nothing else. So they will raise queries. Queries are basically on novelty. They will cite some research paper, they will go through some review papers, they have a worldwide database, they have all the paid, they use PatShare. I want to let you know that the best patent search paid site is PatShare, PATSHARE, that I use. Even patent office also use the same. There are free databases for patent search, such as World Intellectual Property Organization. So that is www.wipo.int. That is the best one, through which you can get information of all the patents filed in all countries together. So once you file a patent application in India, after 6 weeks means 1.5 months, it will be communicated to the WIPO. And you can see your patent applications on the site of WIPO also. So WIPO keeps a database of all patent applications, so you can get an idea about all patents filed all over the world. Beside that, you can go to individual patent office sites such as ipindia.nic.in or USPTO for US patent, eSpaceNet, Europeans, Japanese, Australian, OSPAT, all you can go through that. But best is the WIPO. Even Google patents are good, that they can give you good results. Okay, so let's proceed about this. Like suppose once we have received objections based on novelty, it is about what is reported earlier and it is similar to you. It may not be similar to you, so you have to justify. And if something is very similar, you have to say how you are advanced, how you have added the human intervention. And suppose if you are not able to do that, then what is the option? Simple option to move back. When we can't fight, we have to move back. Very simple. We have to be very flexible about it, because we have to respond to objections within 12 months. So how to move back? Move back is we can remove some claims. We can amend our patent applications on request by the controller. And we can modify it. We have the full opportunity of that. So when we feel that we can answer, we should answer. If we feel that we can't, we should amend it. Once we amend or remove the claims or reply to objections, patent office examiner may become satisfied and patent application is put in order for grant. As per section 43, they are granted and all the rights are conferred over to the patentee, such as they can make, use, sell, offer to sell or import the patented product, and excluding all others, with a monopoly right of 20 years. So suppose about 3 years have lapsed during this prosecution state, even then there are 17 years to market a product. And we can import also. We can use it, sell it. We can sell the product, we can offer to sell, we can license. We can do anything with that. The name, address and everything is registered in the Register of Patents, and our patent is published as a granted patent. So just go through a process as a ready reckoner. First, we file a patent application with a provisional. And if we are able to file the complete specification within 12 months, if it is fine. If not, application will deem to be abandoned. We can directly file the complete specification if we are complete with our product, our findings are ready, our claims are drafted. We can file the complete specification directly. It is published through normal process after 18 months, or we can go through the expedited publication. After publication only, it is in public domain. It is open for pre-grant opposition, and pre-grant opposition could be filed by anyone, not necessary to be an interested person. Anyone can see and can file. Actually, it helps in the patent office in finding out the loopholes in your patent application and raising the queries as much as possible during prosecution state. So once it is published and you file a request for examination by filling the form 18, only then the patent application will be examined. So after examination through normal process or through expedited process, the first examination report is issued, and the queries are raised, many queries are raised, And we have to answer the queries within 6 months, which is extendable up to 3 months if we can request for extension of time. So, and yes, once we answer those queries, then in the prosecution state, they may ask for hearing. Sometime 3 times hearing, 4 times hearing, many times they can call you for hearing. Every time we have to appear for hearing and we have to answer the queries raised. And once they are satisfied, they will generate the reports. Otherwise, they will say you to amend it. Remove that, I'm not satisfied. It is not novel. Remove some claims, amend it. They may say you. So we have to be very flexible in that. And if objections are met within 6 to 9 months, we can get the patent granted. Otherwise, it will be deemed to be abandoned. This is the way through which the process goes on. This is the form many of you might have filed. I'm not showing it for the first time, but yeah, the applicant's name, nationality, address, inventor's name, nationality, address should be in the form 1. Title of invention, the full title, then the address. Then if you have filed in any foreign country and going through PCT route and now entering in national phase and filing form 1. So in that case, we have to mention the details of convention country, PCT applications. If it is a divisional, we have to mention the reference number of our first application. Patent of addition also, we have to mention the main invention first priority number and date. It is not just right here, not applicable. Just write NA and draw a line and just pass it. After that, you have to declare, After that, you have to declare that this is the first provisional specification. We are the true and first inventor. This is either PCT or divided or patent of addition that you have to mention here. So wherever it is not applicable, just write here NA. And then normally through paper filing, we have to make a demand draft of 1750. It is 150 rupees extra. And then we have to put our signatures and send it by post. Otherwise, you can go for online filing. In that fee is 1600, and then you don't need to mention anything about the draft details and all. Just you have to write down the attachments. Attachments are important. Form 2 and 3. These 2 attachments are very important along with form 1. So form 2 is your technical specifications and form 3 is your declaration of foreign filing. So these 2 are important to be attached. Now your signatures and date. This is done. Now form 2. Form 2 contain your technical parts. So first of all, you have to write down the title of invention. I'm just telling you how to write the content. I'm coming to that point. Then applicant's name, address, nationality, addresses, then description, then claims, then abstract. Then how it should be. Form 3 is nothing, but you have to write down the name of applicant and just write down the name of your patent application reference number, the date of that, and just declare that we are not filing in any, we are taking the undertaking that we will keep the patent office informed about our patent filing. And then we have to just put our signature and date and we can submit. Every form has to be converted into PDF document, digitally signed on the site of Indian Patent Office and submitted. Form 5 is required only when applicants and inventors are different, otherwise not required. Form 9 is for publication. Here also just you have to mention the title of invention, name of inventors, reference numbers, and just put your signatures and make a PDF and upload. And after that, you have to digitally sign it. Then only it will be considered valid. Form 18A, this is also the same. You have to just mention, these are very simple forms. Once you open it, you will see that just the title of inventions, the patent application reference number, the date of patent application, these things are to be there. And then you have to put your signature and name. What is the content of patent application? Now see, because we are all going to prepare it in future or might have prepared it in past. So first of all, title must be of 15 words and should reflect the main art of the invention. We have to write down exactly, because like our thesis title or anything, we have to mention what we are preparing and how we are preparing. Field of invention, it should be very crisp and clear and should cover all the scope of our innovation. What we are going to do. Explain the background. Background is we have to cite some of the patents that are similar to us, but how we are better. And once you are writing down like a literature, this patent says this patent says this, at the last draft your own paragraph and write how you are better, how human intervention is involved, how inventive steps are considered, and how technical advancements have been incorporated as compared to the earlier reported prior art. So background should be very strong. Object should be written what you are going to achieve, the same as the objectives of our innovation that we write in our presentations. And then statement of invention. Statement means what novel features our innovation has, and what we are going to introduce in market that is not there already existing. So inventiveness should be highlighted in the statement. What is important? Your summary and description. So summary will contain your detailed description. So write everything. And your claims should be based on description. If something is there in this claim and not mentioned in description, patent office will say you to remove that claim. And then you will lose some of the rights of patent. So first draw a big description. Then from that, draft your description should incorporate everything. Then if you are incorporating any drawing or illustration, numerals must be used to label the parts, and those parts have to be elaborated. What is the functional prospects of that part? So brief description of drawing must be incorporated in the patent application. Detailed description, claims. Claims are the detailed description is the complete picture, and patent office say that any layman or any person skilled by going through your patent application, it should be like that. And claims are the essence of the patent. So one independent claim should incorporate all the features in broad, and the dependent claims should elaborate every small features that was explained in broad in a very elaborate way. So dependent claims are elaborating each and every component that is mentioned in the independent claim. So claim drafting is very important for the grant point of view. So I'm giving a small highlight about it. You might have gone through it. First of all, we have to write down the preamble, then transition phrase, and the body. So what is the preamble? Preamble is what is our innovation. Is it apparatus, device, article, composition, method, or process? Suppose an apparatus for cooking. If I have a claim, this is the preamble, which is very broad. But suppose if I'm writing an apparatus for cooking grains, anybody else can file a similar patent. This is nothing but a pressure cooker patent. So they can write an apparatus for cooking vegetables. So they can enter the market simultaneously. But if I write an apparatus for cooking, so definitely nobody can enter along with me. Transition phrase that connects with the preamble with the body. So if I'm using an open-ended, such as including, containing, characterized by, means it can include something else. So this can give us a benefit of including something more. Suppose just for example, this is an apparatus, this is a preamble. After that, it should be separated from the transition by a comma. And then after transition phrase, this is a syntax to include a colon. And then all the body of the claims must be written separated by semicolons. And it is important to link each and every component together. You cannot list it. Just for example, if I'm writing in this way, suppose an apparatus for holding items comprising 4 legs, 16 screws, and a top. Here it looks like this is just an assembly or arrangement of components. So as per section 3E of non-patentable statutory items in a patent act, this is considered to be not patentable. Even if we have did a lot of inventive steps, made a product and not drafting the claims in a proper way, this may be rejected and they will say that this is a not patentable subject matter. This is just a assembly arrangement. So how to write it? First, you have to write a preamble, an apparatus for holding items, comma, comprising colon, then at least 1 leg, semicolon, and a top configured to support at least 1 leg. So we have to write in such a way that all the components are supporting each other to make a unit invention. If we are listing them, yes, these are the parts, but listing makes them unpatentable. So this syntax part is very important, like how we can arrange the components and can make in such a way that they are working together. to make an apparatus for holding items. So in this way, we have to write. So if it is a closed phase, transition phase, so if we are writing as consisting of, it means it is containing only this, not anything other than this. So we cannot go beyond that boundary. So this is our independent claim. If I'm writing consisting of, in the dependent claim, I cannot claim anything other than these three. So it's very like suggested thing is like we have to use the open-ended phrase, comprising, containing, characterized by. Such claims gives an opportunity to include something else in the dependent claim if it is not broadly covered in our independent claim. So in dependent, we can add something more if we are using a open-ended phrase. So in this way, we can draft our claims. Just in short, claim, this is the syntax. We have to use some special words, wherein, whereby, by which we can give some functional aspects or some of the operative way by which it can operate. So suppose for an apparatus, comma, always write this comma between preamble and transition phrase, and then you have to put a colon. Then you have to write the bodies, different components separated by semicolon, the last one to be added by this end, and at the last you have to put a comma and write wherein. Wherein means now you are explaining about the components. So you can add this word to explain the improvement or the functional features to make it an improvement claim or a Jepson claim. So Jepson claim is a very strong claim where you are adding the innovative features in your first independent claim itself. So in this way, the broadest claim after that, but you know, broadest claim is very strong claim, because if you are not including something in your broadest claim, your dependent claim cannot elaborate anything that is not reported in broadest claim. But yeah, you can use open-ended transition phase as a remedy, just as a supportive remedy, I can say. But try to include everything in your broadest claim. And yes, your first independent claim could be one sentence. That one sentence could be 1 page long. Add up by semicolons, everything, and attach by and at the last. This is a way by which you can incorporate every broad elements, but never write narrow elements. Suppose just write, suppose pH sensitive polymers, that is fine. But you don't need to mention all polymers because it will be very cumbersome. Write all polymers range in your dependent claims. So in this way, claims are drafted. Just this is one independent claim. A game device, this is a racket. Game device having a handle, always write comma, a throat portion and a head portion connected to the throat portion, wherein the improvement comprises a protrusion secured to the handle. So now you have to dwell inside that. So in the second dependent claim, you have to write like this, a game device as claimed in claim 1, or you can write according to claim 1, then comma, wherein should be written, because now you are elaborating what is claimed in your independent claim. And while elaboration, you have to write down something more. Suppose wherein the protrusion is configured to receive the palm of the user. What would be the third dependent claim? The third dependent claim would be a game device as claimed in claim 1, wherein the protrusion is made up of rubber material. So I'm like claiming something that is there in the claim 2 and elaborating the material of the protrusion. So in this way, I can elaborate more and more. So, but just depend on this. You have to depend on whatever is claimed in our independent claim. So this is the way by which claim is drafted. At the last, we have to draft an abstract that should be 150 words. Always remember, first write down the title of invention, because patent office may raise an objection for a small change to make it. So first write down your title, then write abstract. Abstract should be 150 words, like an executive summary, and it should highlight the basic technical features of the innovation. And then disclaimer. Disclaimer is a legal word that normally the attorneys write. Is like, suppose we have to do some disclaimer, like whatever is reported in the patent application is as per the findings and as per the outcomes done during experimentation. And if some more findings are observed in future, that will be included. And whatever is reported is based on the true facts and findings of the innovator, like any disclaimer. So we can write here as such. Now I'm coming to some of the important case studies in the pharma. field that are the landmark cases of Indian Patent Office. So if you have any query in between, we can discuss. Otherwise, I am shifting to some of the landmark cases of the Indian Patent Office. So, okay. So I'm shifting to now the landmark cases if there is no question. Okay. So first of all, the case study of Novartis versus Union of India. So this is a case when Novartis, a big pharma giant, fought for 7 years in Supreme Court for grant of their blockbuster drug, imatinib mesylate, that is Gleevec. Gleevec is like you can say, a landmark drug because it was generating a lot of profits to Novartis. So what has happened? Actually, imatinib was there in market. It was getting expired after 20 years. What Novartis did is like just before the expiry of the patent, they filed the patent application in the Indian Patent Office as the beta crystalline form of imatinib mesylate. So they filed the patent application before 2005. So they filed about in 1993, imatinib was patented worldwide. Then in 1995, India joined WTO, World Trade Organization. TRIPS agreement compliance was like India tried to comply with that. They joined the TRIPS agreement. This all process were going on like a history. In India, there was a mailbox provision through which patent had been filed in India. That was there in the mailbox and that is opened at frequent intervals. In 2002, Gleevec was launched in India. In 2003, Novartis was awarded exclusive marketing rights because in India earlier there was no product patent, only process patent was there, and no patent rights, just the exclusive marketing rights procedure was there. In April 2005, what has happened? A big amendment took place. Product patent in India is introduced. Now, and Section 3D was introduced. Section 3D says that any salt, isomer, polymorph, solubility enhanced products, crystalline products, any such kind of similar products, salts or anything are considered to be the same substances as the main drug, unless until the efficacy is proved. Now, what about efficacy? It's not about stability, not about solubility enhancement, not about anything. It's just about bioavailability. So patent office says that unless until you bring the salt form with a very good enhanced bioavailability, I will consider the imatinib mesylate and imatinib as the same drug. Patent will be rejected. So Indian Patent Act rejected the patent application of Novartis Gleevec under Section 3D. Novartis appealed. Why? Because they wanted to evergreen the patent. Already imatinib was there in market of Novartis. It was going to expire. They were about to launch. In fact, they have got the rights of imatinib mesylate, the beta crystalline form. So again, 20 years. So lot many people came in opposition. Government labs were in opposition. Many pharma companies were in opposition. They were all opposing because they didn't want Novartis to evergreen the patent. So Novartis appealed the decision to the patent controller. Patent controller rejected it because that was a very new thing that was introduced to Section 3D and product patent was introduced. Now patent office was very adamant. Now very simple innovations, salt form hydrochloride will not get a patent. You work hard. In a pharma industry, R&D must be done. R&D should be the core of a pharma industry and then only anybody can launch the drug in market after a lot of innovations, not just introducing a simple salt form or solubility enhanced or beta crystalline form that are easy to do. So it was just to promote the R&D and to prevent such parties which are launching the similar kind of products in market with little human intervention. So after that, R&D actually got a boom in the pharma field especially. So after August 2006, when the patent application is rejected in Indian Patent Office, the provision is that pharma companies go to High Court. But nowadays it is the provision. Earlier it was there before amendments that pharma companies can go to intellectual property appellate boards. So that is a separate constituent body that is being constituted to resolve the disputes arising out of the innovator and the controller of patents. So to solve such dispute, Novartis approached the IPAB. IPAB also rejected it. After rejection by IPAB, Novartis filed SLP under Article 136 of Indian Constitution and went to Supreme Court. They fought for 7 years. Litigation was there. You can see after this so much time, in April 2013, order of Supreme Court came and they rejected it. Simply meaning it was in support of Section 3D. So we have to be very much sure once ever we do some solubility enhancement or anything, we have to be sure that if we want a patent of that, we have to do the kinetic study. And we have to be very sure that how much bioavailability you have established. Because I'm giving you again a case study whenever a company has enhanced the bioavailability to 40%, but then patent office rejected it. Because the case was that it has to be even more than that. So that was the scenario that patent office was not considering any simple product. So this was the case study. I'm coming to the point of the Hoffman, Roche and OSI and Cipla. But OSI, just you can say that interference was done by OSI. Major fight was between Roche and Cipla. So what was the case? The case was for Tarseva. These are the case studies which you, I think many of you might have heard about. So that was erlotinib. So erlotinib was what was there? Actually, Roche was saying that Cipla is infringing. What was the Roche product? Roche product was erlotinib hydrochloride. Erlotinib hydrochloride is nothing but a composite compound that might contain polymorph A and B both together. What Cipla did? Cipla launched a polymorph B of erlotinib hydrochloride and said that this is better and launched it in market. Roche opposed it, said that Cipla drug is very similar. Polymorph B is also already a part of the composite mixture of erlotinib. How it is separate? They are launching the same drug as mine. But patent office allowed Cipla. Actually, this was a case when patent office said that Cipla is also not infringing, Roche is also correct. They allowed both of them. Why? Because Roche was not mentioning that this is a mixture of polymorph A and B. And Cipla launched the polymorph B. And yes, Cipla was having the bioavailability proved. It was showing betterment. And a different purpose, the real purpose for which the product was invented. So patent office considered that polymorph B is a more purified form, more efficacious form for giving the action, and they allowed Cipla also. But you know, they fought together with each other for long in High Court. And after so much years, they again came to a settlement just 3-4 years back. And after settlement, both have decided to share some of the profits made by Roche and Cipla together. And then they are entered the market together. Both are selling their own drugs. So this is the interference where patent office sometimes feel that if you are actually preparing a polymorph that is a real one. What is the need of polymorph A then? Polymorph B is efficacious. So why not to actually prepare a product of polymorph B and launch it, because it is really efficacious. So, but Roche has already a patent of A and B. So it was said that Cipla is not infringing and Roche is also novel. Both are entered the market now with the settlement among both of them. So this is a case study. Another is about compulsory licensing. So this is very important. Whenever any student, especially if we can get the grant of a patent. So what is important here? After grant, within 3 years, we have to prove that, and we have to submit a form to Indian Patent Office that we have manufactured a substantial amount of product in India, not imported from outside. And we are catering to the needs of the people of India. So through which we are actually utilizing the patent rights. But suppose if we fail to utilize, and some other company is continuously monitoring us that yes, we have the patent right, but drug is not there in market. If it is there, it is very less quantity. We are not fulfilling the demands. They can approach us for licensing. If we deny, they can approach the government and government can interfere and can say me to give my patent rights to another company. So this is the case that has happened with the Bayer versus Natco. So the drug was sorafenib, Nexavar. So what has happened? Here, Natco, a generic drug manufacturer was there, requested Bayer for giving the voluntary license. Bayer was actually the patentee. Natco was asking for patent rights. Bayer denied. Then the patent controller interfered and snatched the patent rights from Bayer and gave it to the Natco. So what was the ground? Ground was that this drug, that is sorafenib, that was for kidney and liver cancer. And Bayer was not supplying and also supplying at very high exorbitant price. But Bayer was saying that there is another pharmaceutical company, Cipla, that is also producing. So the demand is fulfilled. Controller of patent said that you cannot refer Cipla to fulfill the demands that you have to fulfill. Actually, you have to fulfill the demands, but you are giving a reference to some other. Cipla is also fulfilling, so the demand is fulfilled. It is rejected by the patent office. And also, they were importing it from outside. They were not making in India. And they were not catering to the needs of the people because there were many people suffering from cancer, but the bottles supplied were very less. So supply was less, and because of such cases, the government interfered. The patent office took the patent from Bayer and gave it to Natco through the compulsory licensing procedure. So in this way, compulsory licensing is based on working of patents. So the certificate of working of patents must be submitted to the Indian Patent Office, and from time to time, within 3 years, one certificate has to be submitted first, and if we fail to meet such a requirement of manufacturing and meeting the requirements of public, somewhere we can give our license voluntarily to other company, and if we are not ready to give, government may interfere. So these are some case study where we can learn exactly how to actually manufacture after getting the patent rights, not only to get the rights and keep it as such. So yeah, I'll be happy to answer your questions because answering the questions will give you more information about the patents. So yes, please.
Thank you, ma'am, for sharing informative talk. Audience, we have open session. If anybody want to ask any question, you can unmute yourself and ask the question. Anyone? Okay, guess audience do not have any kind of question, ma'am. So moving further, as a token of respect, I would like to share a certificate for you, ma'am. 1 second.
Thank you so much.
So, ma'am, this is a certificate for appreciation for your informative talk today, ma'am.
Thanks a lot to everyone.
Thank you, madam.
Thank you, ma'am. Thank you so much.
Thank you so much, ma'am. Pleasure, ma'am.
Thank you, sir.
A man may be, moving forward, a man may be a pessimistic determinist before lunch and an optimistic believer in the will's freedom after it. Yeah, that's correct. It's a time for lunch. I request you all to please join for the remaining plenary session by 2:15 p.m. after the lunch. Thank you, one and all. We will shortly begin with the next session.
The times are changing, and so is the world around you. At CVM University, we help you prepare for the future, like we have with more than 10 lakh students. Come, join the education legacy of 75 years. CVM University, enlightening the future generations.
Welcome all back after the lunch session. Now we will proceeding with our next plenary session. I hope you have enjoyed your lunch. Coming up with our next speaker is Mr. Sanjay Kumar Patel, founder, patent and trademark attorney, Excellon IP, Ahmedabad. Sir will introduce us about drafting of claims. I would like to request Dr. Veena Patel, HOD Pharmacognosy Department, ISCP, to introduce Mr. Sanjay Kumar Patel. Sir. Yeah, ma'am. Over to you.
Thank you, Harita madam. It's a great pleasure for me to introduce our next speaker, who is going to talk to us about the drafting of claims in Kujko's sponsor one day on patent and its implication in pharmaceutical industry. Mr. Sanjay Kumar Patel is the patent and trademark attorney at Excellon IP law firm with 16 years of experience in IPR field. He is a registered agent. He has done BPharm and MPharm from LM College of Pharmacy and has done LLB from MS University. He is holding PG diploma in patent law from University. Previously, he had worked with B&S Group UK, Alembic Pharma, Astron Research of Intas Pharma, and Torrent Pharmaceuticals. He is active member of IP Collegium Group of Japan, managed by Japan Institute for Promoting Invention and Innovation, representing as patent attorney from India. A startup IP facilitator recognized by JPIIT. He's on IPR panel as IPR experts at Atal Incubation Center, LM College of Pharmaceutical University, and many other universities and colleges. Sir has been listed as top 100 IP leader of India by World IP Forum in 2018. He is seasoned speaker and has delivered many lectures and presentations at national as well as international conferences. On behalf of INDUKAKA IPCOWALA College of Pharmacy, I welcome you, sir, to grace the audience. Please, sir.
Thank you, madam, and thank you, the team of IPCOWALA College of Pharmacy, for giving me this opportunity. Hope my screen is visible and my audio is audible.
Yes, sir. Absolutely.
Thank you, and I hope you enjoyed the session in the first half related to patent. And today I'm going to discuss something related to patent claim drafting. And you have gone through or might be aware about the word is patent. I would really gone through the process of patent searching or patent filing related, or maybe you are in the planning to file a patent or to do the patent search or patent drafting in your future work. So this is basically will look more detailed what is actually the claim is. Need to consider when they are doing the drafting of the claims. But before that, we just start with the basics, come to a particular topic of the today's discussion, that is claim. So is what is patent means? What do you understand, or how you define the patent in a layman language? I'm not asking, but if anybody can unmute and let me know what do you understand by patent?
Participant can unmute themselves. Feel free to interact with the sir.
Good afternoon, sir.
Good afternoon.
The patent means it is an exclusive right through which if we discover something medicine or something new, then we register it to government and we only can use and formulate some uses, then he must pay us or take permission from us.
Okay, yes, absolutely right. So if you go, it is an exclusive right given to an inventor on disclosure of the invention, which is either product or process, and which is novel, inventive, and industrially applicable. So it is an exclusive right given to the inventor who has invented something on disclosure of that invention. Right? That condition is that one has to disclose that invention, and that invention can be in the form of product or process, but should satisfy the criteria of novelty, inventiveness, and industrial applications. Here the disclosure is bold out because the patent rights is given for disclosing your invention, not keeping it as a secret. There is another term that is trade secret, and this is patent. You have to keep your invention or idea or USP trade secret without disclosing to. But if you want to file a patent, you have to disclose your invention. And any patent will be evaluated or examined on these three criteria. That is novelty, inventive steps, and industrial applications. Now, how one can define all these three things? First is novelty. Novelty means the invention you claiming as your invention should not be into the public domain anywhere in any form. Means it should not be into the public domain anywhere into the world, not in India, but globally. वो information, वो product या वो invention ही होना चाहिए. Though you are filing a patent only for India, but the novelty is to be evaluated globally and in any form. Means it should not be into the public domain in any form. Means it should not be published in any particular patent, any article, any book, any audio, video, or assets. Product should not be into the public domain or the in a market. You can say that that invention is novel. Second is inventive. Inventive step means suppose exactly the same information is not in public. A similar kind of information is mentioned somewhere into some patent or article or book, or similar kind of product is available in market. So now in comparison to that information which is available in public domain, you have to compare your invention with that, and you have to prove that there is some significant or technical advancement in your product or in your invention, which is giving you the significant benefit compared to the what is known to the public domain. Right? To prove that through supportive data and information, then it can be considered as a inventive steps. And third is industrial application, which is by default applicable to most of the invention. That means you are able to manufacture that product or a process at a commercial level. Right? So these are the three criteria. So whenever you are thinking of filing some patent or something, the first thing you need these questions to your invention: that is my invention is novel, is my invention is inventive, and is my invention is industrial application. Because the examination of patent at the patent office will be done based on this thing. Apart from that, you also need to consider that is your invention is falling under the non-patentable invention or not. Because patent law, they have given some exclusion or exception patentable as per Indian patent law. So all the section 3A to P as well as section 4, they have mentioned the list out that these are the not patentable invention as per Indian patent law. That might be patentable in other countries, but as is not patentable. If I say examples, some discovery, mathematical equations, method of treatment, method of surgical, method of doing surgery, or method of diagnosis, software, business concept, business method, all these things are not patentable. It might be patentable in other countries, but not patentable in India. So you have to that is my invention is fulfilled in India, and my invention is not falling into the non-patentable inventions. Now, steps before drafting, before you start the drafting of your patent, what are the things you need to consider? The first thing is what is the invention? When you come up with any invention as a product or a process or a composition or whatever, the first you need to identify, you need to understand what my invention is. Second is you need to evaluate that is it patentable? Is it patentable according to the 3 patentability criteria? And that you can identify or evaluate after doing this prior art search. Prior art search is nothing but to performing the search into the worldwide database of patent as well as non-patent literature similar to your invention. Right? So once you perform this prior art search, you can identify some documents, either PHARMACEUTICAL, which is disclosing or which has the information which is either same or similar to your inventions. Identify the problems in prior art. What is the problems have to be solved by your invention? Suppose you identified 1 or 2 documents which is related to your inventions. What are the problem in this existing information or the public domain of the document? You can propose the solution to that problem through your invention. And again, evaluate that is your invention is not inventive. That is also you can do by comparing whatever the document you have identified after the compare the information disclosed into those documents with your proposed invention, and you can based on that you can analyze and evaluate that is your invention is novel and inventive or not. Now, have you read or gone through any patent documents? Have you read any patent document till date?
Sir, our second speaker has just elaborated the different parts of patent document. So I think participants are aware, somewhat aware about
it. So when you read any particular patent document, this type of heading into the patent document, there is title, field of invention, background of invention, object of invention, summary of invention, detailed description of drawing or figure, detailed description of invention, examples, claims, right? If you find any patent of any country, more or less you will find all these headings, and under these headings you will have a different information. Now, out of this is the main critical part and the main important part of the whole document, right? You might have the patent with 100 page, 200 page, 300 page, but out of that 300 page, the more critical part is the claim portion. We discuss about what is the objective of keeping claim into the patent. The claim is defining the clearly and precise your rights. If you say that I have patent right of these inventions, the legal right will be defined what you have mentioned or what you have drafted into the claims. To define the scope of the invention, the claims, out of the whole document, only the claim is defines the scope of your invention. Now that needs to be understood, because either you want to do the patentability search or you want to do the invention search. you need to understand that what the claim scope is. To define various necessary, preferred, and optional features of the inventions. In upcoming slide, we will what is the necessary, preferred, and optional features of the inventions. Every complete specification must end with a claim or claims. So whenever complete specification or a complete patent, it is mandatory to have at least one claim. If you do not have a single claim, this patent will not be considered as a filed or considered as a fully compliance as per the patent law. So when you're filing, you might be aware about the provisional patent and the so when you're filing a provisional patent, at that time it is okay if you are not right. So in provisional patent, it is allowed to file without claims. You're filing a complete specification or a complete patent, at least one claim. Now we come to the structure of any particular claims. It is always divided into the three portions. That is, first is preamble, transition phrase, and body. So whenever you read any claim, any particular claim of any patent documents, you can classify the whole claim into three portions. First is preamble, second is transition phrase, and third is a body. Right. So what these three R's will discuss in. So when you are writing a preamble, you have to ask the question: what is the object of your invention? Given three examples, right? The first object is object of the invention to rice. So in that case, your preamble will be an apparatus for cooking. Be an apparatus for cooking rice. Now, second objection is object of the invention cooking all kind of grains. Right. First is only for rice. Second is for any kind of grains. An apparatus for cooking grains. To refer the third object of invention is to also cook a vegetable or other foodstuffs. So in third case, there is no any limitation to any particular grain, any particular vegetable, any particular food items. So it is broadened. So if you see the preamble is an apparatus for cooking. In first case, it can be an apparatus for rice only, rice. Second is for any type of grains. Third is for any type of food source, right? This is the preamble where you can define what is your object. Another example is your object of your invention is a composition for treating a malaria. Then your preamble solution for treating malaria. Another object is a non-motorized vehicle. So your preamble should be a non-motorized land vehicle. Mounting telephone, a device for mounting telephone, right? So first you need to identify actually what is the exact object of your invention. Accordingly, you can put your preambles. Now, second portion is a transition phase. Now, transition phase, what it is doing is it is connecting your preamble. It is connecting your preamble with a body, and terms generally using into the claim language, that is comprising. To define the comprising, it is open term saying that following, but not excluding others, right? So if you read any particular claims, but trans is comprising, that means that it has these elements, but it does not exclude others. We'll refer further into the examples. Another is consisting. Now, consisting is an open term. Consisting is a closed term saying including this only. So when which has mentioned consisting, after consisting, what are the elements they have mentioned? That scope of that claim is restricted to that only, right? So when it is the term is consisting, the scope is very limited to that element only and not allowed any other elements. Consisting essentially of, it is again a intermediate term between the comprising. It is generally very rarely used. Most of the cases, the comprising word is used, but when you want to narrow it down the scope, then you can use the consisting, right? So these are the three transition phase which are very widely in the claim. Okay, now so we have discussed about the preamble. We have discussed about the transition phase. Now body is nothing but of your invention, right? So if you are saying that a pharmaceutical composition having a compound, diluent or disintegrant or lubricant, so that elements, that drug, disintegrant, diluent, and lubricant, these are the elements of your invention and that body. So preamble is your object of invention. Transition phase is connecting preamble with the body. Body is the part where your exact inventory features will come into the picture, right? Features of the claim. Now, when you are drafting the claim, you need to consider that it should relate to a single invention. As per law, only one patent is allowed for one invention. That is also called the unity of invention. So, the claim should relate to a single invention. There should not be a multiple invention into the claim. So when you're drafting a claim, you have to make sure that your claim is related to a single invention, not is the bundle of invention. Should be clear and concise. Hence, it should be clear and concise. That you cannot use any vague term into the claims. Vague term means if suppose you are saying that a product having the higher stability, right? If you are saying that a pharmaceutical product comprising drug X, which is most stable or higher stable. Now here you use the word most and higher. Now it is a vague term. It is not clear term. Higher means what? How much higher? Most. It is also approximate to the vague kind of term. So you should not use that kind of vague based on the matter disclosed into the specification. Whenever you are writing anything, any terminology into the claim, it should have support into the description. Or when you are writing it down that by pharmaceutical compositions comprising a stabilizer. When you are putting this word stabilizer, you have to define that stabilizer terminology into the specific. So whatever you are writing in the claim should have a support into the specifications. Now, principal claim should define all essential novel features. Essential novel features. The main features of your invention should be covered into the first claim, that is called a principal claim or an independent claim. We will see the type of claim also. All your essential novel features should be present into the principal claim or an independent claim. Optional feature may be given into the subordinate claims. Right? So your first claim should main features. Optional features you can put into the subsequent claims or the dependent claims. And format like this, I claim to be inventor, I claim some reverse, I claim effective. Such kind of term or such kind of language must be avoided because it is not claim format, right? So when you are drafting the claims, you need to consider all these points clean. Now things to be remembered. The first thing is the foremost thing is you understand the invention. Find the exact essence of the invention. What are the crux of the invention? What are the most important element of the invention? Find the right embodiments. Find the right words, terminology, and sentence to describe the invention. So that all thing will be easy if you are able to understand the invention very properly. Right? You should actually invention is into the product, it's a process, it is a device, it is a combinations. But in product also, which is the element for giving that result? Well, based on which you are claiming that it is an invention. So you have to understand that thing first. If you understand that clearly, you can then define the further features for the claim drafting. Now, if we consider the type of claims, there is an independent claim and dependent claim. It's a self-explanatory that first claim is always an independent claim, and all the claims dependent on any other claims are called dependent claims. Right? If you read the claim, you can find out that a product composition according to claim 1, claim 5, as claimed in claim 7. Claims are the dependent claims or subordinate claim. So independent claim and dependent claim, or principal claim and subordinate claims. These both are synonyms. Composition being some type of composition. It can be a chemical, it can be a pharmaceutical, food composition, or any other compositions. Method of treatment claim. So method of treatment, method of use, method of indications, this type of claim, then it is defined under the method of claims. Device or a system claim. If you are claiming one kind of device, it can be a medical device, it can be another engineering device. So when you are coming up with a whole system, which is a combination of hardware and software, through which you are doing some innovation and creating some result which is novel and inventive. Means product is already known, but when you come up with a process which is really novel, so there is another option that you can put it as a product by process claim. That means product X comprising the steps. So such type of claim is called a combination claims. When you are having in term of pharmaceutical, when you are having the two combination or the three drug combination, you can put the combination claims. It is nothing but you can say the second medical use. The product is already approved in market for one indication. Now someone is coming up with a new indication or second indication of that existing product. So to claim that second medical use or second indications, patent and the claims, that type format is I might have the format of this in the upcoming slides. So that is Swiss claim is nothing but a second medical use or new indication claim. Omnibus claims. Now currently it is no more in a use anywhere. Just like to overcome the objections of that supported by the descriptions. So when you write a omnibus claim, it means that composition as described into the specification or as described into the examples. It was used earlier, but now it is no more used or acceptable by any patent office. Jepson claim. It's again Jepson claim, or you can say the improvement claims. So when you already have one product and you have come up with some kind of improvement into that, so in that case you can write the claim in the Jepson claim format, where you specifically highlight that this is the improvement on existing product, and your claim or scope should that improvement portion only. Right. So this is the example of this omnibus claims. As I told you, an apparatus for harvesting corn as this distance. A juice machine is shown in figure 4, right? As I told you, but it is now no more in practice, and no patent office is now allowing it product by process. As I told you that it claims a product defined in terms of a process of manufacture. Jurisdiction or some country consider it as a product claim, some consider it as a method claims, but verify that the product by process claim is the best approach for protecting an invention before employing this type of claim, right? So if you are able to project it as a product, that is first product, but if it is only and only process, then you can always have a option to make it as a process claim. But if you want to project it as a product, but when your invention is into the process part, then you take this option and propose your claim as a product by process claim. This is second medical use, that is a type of claim, right? So here nothing but the suppose chemical compound is already known and already approved for the treatment of the diabetes. Now one comes and identify that it can also be used for the malaria. So the claim format like this, they use Z in the manufacture of treatment of malaria, right? So use claim also known as a Swiss type claims. So it as it is a second medical use claim or indication in India, it is not allowed, right? As per Indian patent law, or method of treatment is not allowed. Even first indication is also not allowed. This type of claim is mainly Europe. This format is also familiar in European patent office. So this is the second medical use or a Swiss type of claims. Use claims similar to method claims. So when you're use of any particular company, the use of substance X as an insecticide, the use of transistor in any predefined circuit. So when you're putting the use of any particular thing as your invention, then you can use this format, right? Improvement claims, I told you the Jepson type claims, that you already have one product in market or in public domain and you are come up with some improvement, then you can use this format of Jepson type claims, where preamble is end of the most relevant prior art. Means what is there already into the prior art, that should be your preamble. Transition phase it comprises, right? It was already, the product is already there in prior art. So your preamble in transition phase you are mentioning that wherein the improvement comprises, and then comes what exactly improvement you have done, that provides the novel features of your invention. So when you are having this, you can use this format of the Jepson type of claims or the improvement claims. Instead of this wherein there is also there is characterizing, right? So that you can both you can use interchangeably. So at the end, this is all about this type of claims. What are the things one need to consider, and what are the do's and don'ts you need to consider for any of the claims. And the most important thing is everything not claimed is disclaimed. That means patent document with doing a patent drafting, but if you have not claimed your inventive features or the element into the claim, which is not claimed and available into the specification or description, is disclaimed. That you by yourself disclaiming that it is not part of my invention. So when you're writing or drafting a claim, sure that essential elements or the novel features of your invention is, and it is not missed out to be claimed. However, mentioned into the patent space not claimed is disclaimed and available to the public to use it, right? So with this, I would like to conclude this session and thank you again for giving this opportunity and listening. If we have any questions, we can discuss it out.
Thank you so much, sir. The session is on for interactive session. If anyone has question, they can unmute themselves and interact with the sir.
Is there any limit of number of claims that we can put it in a patent? Like number of claims?
There is no any limit of the claims unless you do not have a limit in your pocket. Because only the 10 claim is free out of 10. There is no any limit. You can put 100 claim, 200 claims. If you are you can afford the fees of additional claims. So until 10, there is no any additional fees. But if you are adding any extra claim beyond 10, that all is chargeable.
And sir, one more thing, like in provisional patent, if you have written certain claims and if you want to, is it possible?
Yes, the amendment is possible, but there are certain limitations that you hit the scope, you cannot broaden the scope, and you cannot add any additional matter. The part of the claims are illegal.
Okay, thank you so much, sir, for a very informative session. As a token of resemblance, I would like to present a certificate to you, sir. 1 second. This is a certificate of
Saving your time. Actually, I just want to message to the participant that sir was busy with another conference and patents. Still, busy schedule, he taken out certain time for us. Thank you so much, sir, for.
Thank you, Dhimba. Actually, there was Japanese conference 10:30 to 2. And between, that's why I have said that it might be delayed by 10-15 minutes. So we schedule it now and again at a photo hearing at patent office.
Thank you so much, sir. Thank you.
Thank you, sir. Before we begin with the last session of today's, that is the time for quiz. I am dropping the link for the same in the chat box. All the participants are requested to click on the link and answer the questions given in the quiz. It is compulsory to get your certificate. Find the link in the chat box. Hello.
75 years. CVM University, enlightening the future generation.
Still, few participants are remaining in the quiz. We are providing more formatting the same. Welcome, Pratik sir. It's time for our last session of today. Okay. Thank you. And our last speaker, resource person of today, Chaudhary. He's advocate and advisor Trivedi and Co. Ahmedabad. Sir will introduce us of prior art search in the patent. I would like to request Mr. Ravindra Kumar Patel, HOD Pharmacology Department, ISC, Mr. Pratik Chaudhary. Over to you, Ravi sir. Ravi sir, am I audible? We will wait for 1 minute. I think some technical errors for the interruption. Ravi sir?
Yes,
Yes. Yes.
sorry.
Yes, sir.
Very everyone. I introduce our main speaker, Professor Chaudhary, importance of prior arts such in a field. Sir has been a fortunate to have both education, which has assisted him in work and science, law and commerce. He is master in pharmacy pharmaceutics, Pharmaceutical University in 2012. He also holds a master LLM from the Gujarat University, having cleared holder a full medal diploma in patent law from NEL, Hyderabad. Past experience of formulation development department of a pharma company. Mr. Pati is an advocate teaching in a civil law, more particular actual property, and is a partner at Trivedi and Co. And associated with the from since 2015. As a partner dealing with the league, she has to play a crucial role in a variety of the intellectual property ranking for the infringement case of the trade security, copyright and design cases, and different cases and has various courts across India. Sir has a special skill in drafting, including IP transport agreement, court clearing, and he has been offered a consult client on the complex matter. Mr. Pati sir has also the deal with the cases from really excellent work. Mr. Pati sir has also write the book titled Handle Book for the Startup and article published by reputed in a journal. Sir has delivered including one of organization of Indian Chamber of Commerce and Industry, Associated Chamber of the India for the industry or for the Sir has also added young innovation to spread the IPR through the program organized by the Institute in MSRD. On behalf of INDUKAKA College of Pharmacy, once again, welcome, sir. Over to me.
Thank you so much. Thank you so much, Ravi. Very brief and in the introduction of mine. I'm really thankful to the Institute for giving me this opportunity to be with our members, the participants, and thank you so much. According to me, I'll just screen first so that So is my screen visible to everybody?
Yes, sir.
Now, I'm aware that the esteemed speaker, if they may have. Am I audible to everybody?
Now you are audible.
Yes, and I think my screen is also visible.
Yes, sir.
Yes, thank you. So this topic, why is important before we understand the concept of patent and patentable invention? It is because art is first bar, prior art is the first bar which has stood or and it has to be crossed by any or inventor before the of coming up with any invention she thinks is patentable. Prior art suggests. Now, these are just basic slides. I'll just skip all these slides. Introduction about what other kind. So, trademark, copyright, design, geographical indication, and the examples are also given. The concept of prior art is kind of patent, which is a property pertaining to scientific innovations. Right. So we are dealing with patent, but these are the other intellectual like trademark, copyright, design, and geographical indication. Now, patents aware, like the esteemed speaker who has spoken before me, they must have definitely told, must have informed all the participants that patent is granted for what? Technology improvement or technical problem in the existing one. There is some problem associated today. If we talk in pharmaceutical part, there is some problem pertaining to solubility of, there is some problem pertaining to absorbability of some drug. So that is a problem. You solve that problem by using some scientific, you come up with the new, making a with some other chemical or with some another kind of salt which increases the solubility of a particular, makes it more absorbable in the body. So all these technical problems are something which, so it may so happen before you think that I want to kind of for bringing a solution to a problem or this approach, I want to use nano particle thing, use solubility. But before you take that step, you must check what all things you did for solving them. It may so happen that some gel out of physical API, use some other kind of delivery technology, absorption must. So, pertaining technology, the current earlier inventions which are already done, these are all things constitute prior. The word prior means something which, and art means the invention or the art. So that is the basic definition of. Now, if there is any publicize it, you cannot. But if the invention is there, indication, you get a patent granted. Monopoly of 20, you can generalize that for further research and development for more patentable invention later on. Now, know that if your invention you think is patentable and it solves all the criteria of a patent, novelty, inventive step, induction, reproduction, then you should not publish and you should not delay in filing the patent because just like inventor may also be doing the same research. So you should not. So as I said earlier, the three patentability are not industrial applicability. Now, why these three are important to be understood? Because as I said, in something which has been done till date, study as an inventor, you must do, and which will provide the citizens of prior art. Why am I saying that three concepts of novelty, inventive stability, prior art is because if you see the patent act, it says what is impact as a definition for what is inventive step and what is ability. The invention means which is not repeated, something which has not been done before. So it is not published, it is not in India or in anywhere in the country in the world before the date application with complete specific, not gone into public domain. So how do I check? How do I check? Suppose today I want to prepare a thesis, like I'm doing a research right now, right? I also think that I should do research in some way. So what I need to do, I need to first of all search. So prior art search, it helps me in crystallizing the invention. It what prior art has to do. It also distinguishing the prior art with your invention. And this is the novelty. Why I'm saying this? If you end up finding something wrong before you initiate your research, that research probably, yeah, but does give something to research and development, give something which solves the problem faced by companies, right? It may be, you may come up with a product that is also patentable. Your product may be, you may come up with a product which requires dosage, like earlier for a particular 800 mg tablet had to be engulfed, by some with a solution that in 250 mg potency and same effect can be obtained patentable. But know what has already been done. You cannot have an idea of the research you need to do. That is the importance of the prior. If you do a thorough prior art before initiating your research work, getting patent would be much higher. So this is, and in order whether your proposed or development or your proposed thesis topic is want to be patent, you want it to be patentable. So you will have to first do a prior art search. Now, what are classified when we talk about prior art? Constitutes prior art. Now, general perception is that earlier a patent over some product or process that is prior art, the only criteria. The earlier granted patent, refused patent, some article published in Science Direct or any small journal is a prior art. So any information which is in public art, it can include video recordings, it can include magazine article, speech by somebody which is uploaded on YouTube. Suppose somebody may have come with an theme or idea, textbook or patents, website, etc. If it is public, it is prior. So it is also prior. Now you may think that I want to develop a dissolved faster which gets absorbed for a particular kind of problem with solubility. But if that concept description is already there, which also discloses the as to how it can be achieved. There is some document in the world which guides you to something. So that is, if you go ahead with such development, the chances of getting less because you are substantially relying on something or some invention which has already happened, which has been referred your patent application. So that is all kinds of examples are there prior. Now, how you can the prior as a researcher, when I did it on liquid crystals of chemotherapy to increase the ketoprofen crystal technology. At point of time, the session which we are having right now, privileged at that point of time because intellectual property, it was not much higher at global level, especially in India. That was the reason knowledge about all these terminologies, inventive stuff, it was not much there. It was difficult to find out that how do I. So what you can refer before you commence your all sources, you must refer to the prior. There are two things: patent and prior publication in scientific news, teachings, online, or some existing product in the market prior. As I earlier said, granted patent, established patent. Somebody may have applied before you. It can. So why all these material are very big, and that you need to invest doing research, not only option of the topic, but also the of what all has already been. These all literature studies from all help in narrowing your path. So suppose you find out that it discloses that X polymer already is used solubility or absorption. So if you want invention, you should not use that polymer, already something known. Other polymer which increases the solubility better is already been used earlier. So it helps you a lot in the scope of research and development, where the importance of prior search. Now, further, after knowledge surpass this test of novelty prior. So you're combining A and D, which is very good. So this A and D are novel. You have found that yes, things are never used earlier by anybody. It gives something new. Now that you need to surpass the step, because the patent office asks whether there is an inventive step product or process. Now it means a feature of invention that are advanced as compared to existing, having economic significance, or both, and invention not obvious to the person. So it has to be non-obvious. For that, you, researcher, must have applied inventive step of which makes it a patient. It is not a question of X process and Z process. You combine it that yes, it is not, it has got, no, it is not, this is not how it works. It has to be some process, kind of an ingenuity applied while doing your results upon as a very good example of what I need for subsequent slide. I'll quickly go ahead. So inventive step is essential. It is required long felt need. Long felt need means basically that, suppose let's take an example of pharmaceutical industry. Particular X drug need was that effects. So the need was that this some research or some product through which these side effect, that was the long felt need. Now if you come with a product which said long felt need and you come up with a product actually has lesser side effect, earlier product which were available in the market counts as an inventive step, and you may get a patent for that. Unit 10 to a technical problem, non-obviousness, significance. So processing cost, your process is some processing cost amounts to a patentable. Very good example is subsequent slide. Problem, you should first identify a problem, then use solution. That should be something, then the prior art, which I just said, should be better than the earlier solution in the public domain. You in arriving the solution makes it patent. So prior, you may learn, you must have by now in this today understood what are the patent application, what is the process of patent. But if you had ascertaining or identifying the prior, there is no scope that you may get the patent certificate. So this is the importance of a very relevant topic to me by the institute. So problem solution will help you in arriving in the inventive steps, which I said is equal to lab steps of person averagely skilled person. Obvious person who must have average knowledge. If he thinks, yes, this is not been done, that surpasses the test, and that helps you patent. Now, this is a very good example of problem and technical solution to a. Now we will see here. This is a very which our office could obtain for our client. If you will see the earlier, the patent process for this manufacturing was that the raw material bromo 3 chlorpropane, input quantity 15 grams. Second ingredient was methyl acetoacetate, and in earlier known process, carbonate was used 560 grams, which was utilized. It was 50 was required, which will give you yield of, and the effluent, that is the bio stage which gets produced, it is. So this was aware of this. Number one, that the water which is utilized on process was very much high, around 1 liter, and effluent generation was very high. So they did research. They found a way as to how can be reduced and effluent. They just carbonate sodium and see the wonder. For each formula, if you see, 315 ml of water is now required, and effluent is also. This surpasses the test of Nobel's inventive step, because sodium methox never ever used for this particular process. And earlier salt which was used, there is potassium, using that there was a problem that more effluent was salt, sodium methoxide, and that limited process patentable, and that the said client would obtain patent invention. So this could, because of the study of which has already been done, so prior to which as a researcher, as a it is very much important. India is boosting ahead in the field of intellectual property. Prime Minister also has urged to come up with more and more patentable invention which would to our development. It is important that all these aspects by the young innovators. Now the third is basically the come up. It should not be something which is at the lab scale. It should be extrapolated at the industry. It should be workable. So it is not like that you pass all the tests, you also get a patent. In the patent is not every every year you have to submit to the patent office, thereby declaring you are using the patentable invention at the industrial scale. Also have to disclose business which you have done patentable process. In the patent register, apply for a patent, that should not, it should also be industrial approach that brings upon a humongous innovator to not just research something which for our pharmaceutical fraternity. So industrial we use in industry, the finished product or essential it can also be a product, and it can be an improved process. Here there is an improved process. Now how many modes can you do patent prior? So basically prior art search or any other purposes. One is decide before you commence with your research and development. It is before filing a patent ascertain that the A, B, C, and D has come up something E, F, G, H. Right. That prior disclosure is to be done by the application, which speakers must have covered in their presentation. Application in complete space disclose that in the patent office that this much has already been done. I have a process which has not been done before ever, and this will be a known art. So at that point of search, search is very much important. What are the types of search? There are novelty search or state-of-the-art search, patent landscape search, trade search, patent family search, and status report. The other four search which are there, which are these at this point of time, but the first, as far as the present level is concerned. So what do we do in research? Novelty is conducted so as to check whether a single invention of a technology similar to our invention exists prior, which I already explained. That's a prior to check whether your invention or novel and non-obvious or not. So we use patent search. Valid search we generally do to prove a patent does not violate any available patent. It may so happen, it may not be patentable. It may so happen that you may not be something which is very much viable, and it has an industrial application, and you also convert it to a product. You sell that for a big company, pharma. So it is not the case that the output, your product is very any pharma company will purchase your novel process. It will not so happen. Any company, any investor will first, it will check whether which you have come up with doesn't somebody else's patent, does it violate somebody innocently delivered? You do not know that you actually violate somebody else's patent. So that due diligence will use your invention for industrial application. Example also, when someone claim that our patent is valid or already can have background defense in invalidating the claim. So some it may come against you stating that it infringes valid patent. So your which you must have done initiating your research, that will place against that big competitor. You can establish that his patent is because already prior art A, B, F, G are already available patent application of that big company, and hence the you for patent infringement are for that also research of prior important. These other types of search I'm not much going into. What I said earlier, it can be in a particular science technology, that is known, product invented. It may not be necessary commercially or physically. It so happens that you may do your own. Later on, you may through XYZ portal could not find anything out of that. But that is not enough. It may be in Japanese, in Chinese language. It may have in a Spanish language somewhere in the pharmaceutical. So that also. So that is the very much important. Description the technology is also a that reading patent or learning about the patent, it may seem that yeah, smooth and easy to go process. It requires a lot and reading and extensive literacy also. So what are the competing arts? Art. What are competing arts? You may come X solution to some problem. Somebody must come up with some solution. Now you have to establish a better solution to the earlier solution. So this is so just being or new, it is not enough. Your solution, then the earlier solution available. So that is competing arts. So that has to be done. Smoothly. Due and prompt disclosure of prior art search in the patent specification marks the prudence of the patent applicant. Now see, section 10 of Patent Act states that you have to disclose everything about your invention. This disclosure about your invention also includes that you as a prudent inventor or innovator must honestly state before the patent office that what has already been done in this field in which you are doing your research or in which you claim that you have got a patentable invention. So you have to disclose that, sir, 1 to 10 things are done. My invention is something beyond this 10. My invention is something beyond this 10 earlier known process or product. So that disclosure, you as a prudent inventor, if you do, so the burden upon the patent office, it reduces, because the patent office will also check your application. They will also assess your claims in the patent specification, that whether it passes the test of prior art, whether they are novel and inventive as compared to the prior art. So if you have honestly disclosed the earlier prior arts in your patent application, the patent officer or the examiner will also feel good that yes, you have done a thorough research, you have done a complete research about the prior art, and you have come up with something which is really amazing, right? And so then your chances of getting the patent, it gets increased a lot. Now, just a minute. Yes. So what are the important steps for the patent? First of all, you do a state-of-the-art search. Then you crystallize the idea behind the invention. Plus you do a research and you generate a working model, because it has to be industrially applicable. It should be working. It cannot be just a concept in your brain that if I mix X with Y, I think it is novel and it will be an invention. No, it has to be a working model. The patent office can also ask you to present a working model before them. They can also ask for illustration or examples to prove that it is a patentable invention. Then what you do, you find out what are the prior arts, you draft the patent specification, the filing and prosecution takes place, the examination will be done. The examiner and you or your patent agent or attorney will deliberate, because there will be queries raised by the examiner based upon what are the lacunas available in your patent application, and those have to be met with the inventor or their patent agent. Then it may go for an international filing also. If you think that yes, it's a viable patent, you can apply for Europe, you can apply through PCT route also, patent cooperation treaty, multiple application. Then the result will come whether the patent is granted or it is refused. It may also happen that some third party, some other inventor or some other company can file an opposition in your patent application, thereby opposing your right to have a patent because it may infringe their rights, or they may feel that you are monopolizing something which is already known. So those kind of proceedings will also take place. Once you are granted a patent, the revocation of the patent option is also available with the third parties, and there are also chances that lack of doing a proper prior art search may attract an infringement suit, means a civil suit, a case in general parlance, if we say a case against you, for infringing somebody's patent. That may also happen. Now, what decides patentability? This is a very good cartoon which will explain you the technical advancement of your invention compared to prior art. So your invention is as compared to the prior art, so that marks the significance of prior art. Now, if you see this figure, it is very much amazing. The first cartoon character says that here is my new invention, and he is holding a yellow jigsaw puzzle kind of a thing. The other thing is that, oh, it looks like mine. And the third person who takes out the jigsaw puzzle or the thing out of the box, he also thinks that these all things are similar. It is because these people have not done a thorough prior art search. They all think that they have come up with something new, but actually it is not. It is only because it is not inventive as compared to the prior art. Now this aspect I have already covered. Now from where you can find, where you can do prior art search, you can read patent documents. You can go to patent search engine like Google Patents. You can go through patent database of various countries like WIPO. You can access WIPO, World Intellectual Property Organization website. It's a very big database of patents and designs and all other aspects of IP. You can do a thorough research over there. You can also access the European Patent Office. It is free to use, easily accessible. You can do your prior art search over there. You can read brochures, journals, the traditional knowledge data library, the news, the web pages, anything can be mode for searching about the prior art. Now this search which you do, it has to be a global search. It cannot be a case that in India it is patentable. No, it's not like that. The patent prior art search has to be a global search. So application, if you file, if you get a grant, the rights which you get will be only for India. So if you file in India, you get a patent, your rights are exercisable only within the territory of India. It does not apply to Bangladesh or China. Now, towards the application, what you do, you find differences. Is there a technical advancement and is there a long-felt need? All of the above in context of prior art search done. If all these three criteria are met, you can file a patent application, and there are chances that you may get a successful patent registration. Now, I think my earlier eminent speakers in today's program may have covered this aspect of provisional specification and complete specification. So I think I don't need to delve into the details of that. But you will see in both these kind of specifications, you will always find the portion of background and prior art in provisional also, and background and prior art in complete specification also. So that is why I say that prior art is a very important topic. If you file a complete specification, there is a separate heading of prior art. You have to disclose what prior art is, what other prior arts are already available. That has to be, dutiful. You have to disclose under Section 10 of the Patents Act. If we go further, what are the situations where prior art search and significance is felt? Now, as I said, before initiation of the research and development, the inventor needs to go through all possible prior arts if the inventor wishes to obtain a patentable invention. Now, what are the demerits? If you don't do a prior art search, what may happen? Failure to conduct a due prior art search will render the invention futile, as the same would have been already known and disclosed earlier. Hence, this is very crucial, guys, wastage of time, effort, money, and talent. So if you don't do a prior art search, all your mehnat which you do for doing a research, yeah, it may be a novel research, I don't say no. It may also help you in fetching up your degree. But if you think of a patentable invention, it will require everything. But if you don't do a prior art search, all your efforts will go in vain. So that is where the significance of prior art search resides. It helps you to decide the scope of invention. It also helps in claiming the proposed invention after due checkup that your invention does not infringe someone else's patent. Now, you may develop something thinking that it is patentable and all, but if it is infringing somebody else's patent, then you will end up into a big trouble, and you will end up paying money to lawyers like us in defending you from a civil case. So good for me, but I will be feeling very bad for the young budding inventors and researchers. Prior art search disclosure in patent specification. So as I said, in patent application which we file, you have to disclose all the available prior art in the patent application, which distinguishes your invention as compared to the prior art. The examiner of patent also conducts an independent prior art search and would be happy to find that inventor has prudently disclosed all the prior arts in the specification. So that also creates a good impression about you before the patent office, that yes, you have done a thorough research and you have come up with something very ingenuine. Now this is an illustration of prior art disclosure in the specification. This is a sample format from one of our database. See how you do a prior art disclosure in a patent application. So in this particular application which you can see on the screen, so background and prior art is shown. In the field of medicament, coating of polymer barrier is applied to oral medicament for serving various purposes as below. Now why we do polymer coating on API or medicament like tablets and all? For masking the bitter taste, to have a sustained release of API, enteric coating, multiple coating, film coating, etc. Now what techniques do we use? So the earlier known technique for masking or for making an oral medicament having a coating, complexation technique, right? Polymer technique. There are many techniques. All these techniques which are already known, you first have to disclose those known techniques in your patent application under the heading of background and prior arts. So you have to describe all those techniques. See, if you'll see here in the third paragraph, you also have to disclose the earlier patent. See, I'll just read. There are various inventions related to coating of drug molecule are published US number so and so, WO number so and so, US number so and so, EP number so and so. So that research also you have to do, that what is already known, what patent is already been sought in other countries, that also you have to disclose. That sir, these things are already covered in so and so earlier applied, refused or rejected patent applications, not only in India but also in other countries. So all these disclosures you will have to do. Those disclosures of patent number you will see. You will also have to explain that what are the scope or what does those earlier patent cover. That also you have to disclose that Udrajet L100 was used. In second patent, Udrajet NE30 and Udrajet L30 was used. In the third patent, taste masking was done by using water-insoluble polymeric materials. So all this prior disclosure has to be done in the patent application. Then this is also very important. Now, having known that these are the prior arts, having written that these prior arts are there in the patent application, then you have to explain also that what are the disadvantages of these earlier known processes. So all these disadvantages you have to list. That in the earlier known process, many of them cannot fully mask the taste. In all the existing technique, polymers are synthesized. Number 3, they use organic solvent, right? Environmental damage. It increases the cost of the process. All these problems you have to highlight, that earlier known process had all these problems. So once you disclose all these things, you file a patent application, it goes before the patent examiner. So the patent examiner will review your entire application. The patent examiner will go through all the prior arts which you have disclosed before him. Not only those, the patent examiner will search other prior arts also in other countries, in other patent database of other organizations, and the patent examiner may cite additional prior arts in your patent application, saying that see, you have disclosed 10 patents, okay, no problem, but there are other 20 patents also about this. Then why we should allow your patent application, and why we should not reject your patent application? Give us a show cause, give us a reason about that. So this kind of first examination reports are generated by patent examiner. If you will see on the top, there is an aspect of novelty, claim 1 to 13, remarks no, means the patent examiner is saying that all your claims 1 to 13 are not novel. Number 2, inventive step, 1 to 13, no, there is no inventive step in view of patent examiner, that your application does not have novelty, your application does not have inventive step as compared to the prior art. Which prior art? That is given at the bottom. If you will see, EP means European Patent 2516384, which was published in 2012. The reference of whole document has been taken by the patent examiner. The patent examiner here is saying that this European patent is a prior art, and as compared to this prior art, your invention is not novel and it does not have an inventive step. So you see, you may do a very good research. The patent examiners are also technical guys like you. They are also coming from pharma background, engineering background. So they will also do their own research. They will find out some prior art document or patent, and they will cite it in your application. And they'll say that there is no novelty or inventive step. See, now the patent examiner also explains that how this prior art makes your invention lacking novelty and lacking inventive step. The blue portion I am reading, the subject matter of claim 1 to 13 of the present application does not meet the requirement of section 2(1)(j) of the Patent Act because the subject matter of claim 1 to 13 is not novel over the disclosure of document D1 and D2. So as compared to D1, D2, that is the European patent and the PCD, the WO2011071 earlier known patent pertaining to pregabalin, your 1 to 13 patents are not novel. So why we should grant you a patent? Because it is something which is already disclosed in the earlier known prior art. So this report, once it is received by a patent applicant or the patent attorney of an applicant, you have to give a reply. So see, this is how the patent agent or the applicants, they give reply to such first examination report, wherein you have to compare that, sir, the document D1, the European patent, and the another document, the WO patent, right? These two patent application has this title, our title is this. The invention of D1 is related to the novel method of preparation of pregabalin. D2 discloses about the preparation of S3-aminomethyl compound, but our process, it is pertaining to this. You have to explain the difference in objective of those two prior art patent and your patent. How your patent is better than their, how your invention is better than the prior art cited by the examiner. That also you have to show. You have to give your own comments on that. Problem associated with earlier known patent and yours. So if you see the fourth column, it is pertaining to the patent application. In many processes, disclosed chloroform is reported for the resolution, which is very toxic. So you found out that in this cited patent, there is a problem that chloroform is used and it is very toxic solvent. We are not using chloroform. It also, the earlier known process also uses bromine, which is toxic and corrosive, and many other disadvantages you may show. Solution you are proposing, you have to propose the solution to solve those problems associated with earlier known patents, and that will help you in meeting with all the objections which are raised by the patent examiner. And once the patent examiner gets convinced that yes, you have distinguished properly the earlier known prior arts, then a patent will be granted to you. Now, why it is important, why prior art search is important? Because before you employ the process or creating a product in your facility, prior art search or prior patent search would help you to decide whether your proposed process or intended product infringes someone's patent. So if you do a thorough research prior, you will assist yourself in not infringing someone's patent. So you are avoiding a patent suit. You are avoiding a civil case against you. Because if you don't do a prior art search, it may so happen that you infringe someone's patent and you may face a patent suit later on. In defending a patent suit, now it may also happen that you are very much sure that you are not infringing someone's patent. You are very much sure that you are not trespassing into someone's patent. But even otherwise, your competitor who has a patent, he files a suit against you challenging that yes, you are committing the infringement of my patent, give me the damages and stop using my process. But if you have done a thorough prior art search, you will be able to defend yourself in the civil action by proving that your competitor's patent is not a valid patent and it is an invalid patent because the prior art search which you have done already covers the patentable aspect or the invention aspect claimed by your competitor. So you can clearly also and very easily defend yourself, and you can also defeat your competitor in a patent suit. The strength of your invention or the granted patent is also tested by investors and incubators, because I understand that the participants must be young innovators and inventors and researchers. So suppose you may have developed something new, you think it is patentable. It may so happen that you apply for a patent, you get a patent also. It may happen. Now, when you go to find an investor, an angel investor, or for incubation, if you go, then those agencies will not, just take up your invention. They'll invest in your patent, and they will invest in your invention to make it industrially applicable. It will not so happen, because they are also investing crores of rupees, right, lakhs of rupees into you. So they will do their own due diligence. The due diligence means they will do a prior art search of your invention. If you have a granted patent, they will compare it with competing art. They will compare it with the prior art, and they'll see whether this patent is something which is valid enough that it can withstand any objection or any challenge from any competitor in the market. If they get a satisfactory answer, they will go ahead and merrily they will invest, and they'll help you in coming or utilizing your patent at the industrial scale. Big companies, when they purchase each other, when two companies they merge, they do acquisitions. The two companies get merged also at sometimes. They purchase patents of other competitors. At that time also they do due diligence. They do a prior art search. They study the patent, or they study the invention in detail to check that whether is it a strong patentable invention. If yes, then they go ahead and do this commercial transactions. So guys, I would just sum up my talk with only 4 points. Number one, it is not only about getting patent, for which you should do a prior art search, but as a young innovators and researchers, it is our responsibility that to assist our country further, we must not only understand the concept of patent, but we also should do a research and development in the field after considering all the aspects to make it a viable invention which actually has some industrial utility and helps us in getting stronger as a big pharmaceutical hub, which we are already there. But as far as innovation and invention is concerned, we need to work a lot. And I think prior art search is something which is the base and foundation of any research. It may get a patent, it may not get a patent. But if it is solving some problem associated with the prior art, it will really help you a lot in your future endeavors and careers. So I think I'll rest my talk on that note, and I give all the best to everybody. Thank you so much. Thank you so much for patiently listening. Thank you.
Thank you, sir. We have interactive session for next few minutes. If anyone would like to ask any question, they can unmute themselves and interact. Anyone? Okay. Thank you, sir, for conducting such a wonderful, informative talk, sir. As a token of resemblance, I would like to present a certificate to you, sir.
Thank you. Thank you so much.
That is a certificate of appreciation. Thank you, sir, once again.
I'm obliged. I'm very much obliged. Thank you so much. Thank you.
Thank you so much, sir, for sparing your valuable time. Actually, it was a very busy schedule for you, but thank you so much for sparing some time for us. Thank you so much.
Thank you.
Yes. So coming together is beginning, keeping together is progress, and working together is a success. It was indeed this mantra of working together that brought us where we are today. So I would like to invite coordinator of today's webinar, Dr. Usman Ghani Chalotia, sir, Associate Professor, IICP, to present a vote of thanks. Over to you, sir.
Thank you,
Sir, you are muted.
Yeah, thank you, Hedda madam. A very good evening to all the distinguished guest speakers and dear participants. I feel honored and privileged to get an opportunity to propose a vote of thanks on this auspicious occasion. First of all, I'm very thankful to all the participants for whom this webinar was organized, and without them, this webinar is not a webinar. And I'm sincerely thankful to our chief guest for kindly hearted accepting our invitations and gracing an inaugural function. I also thank to the management of the college, Charuta Vidya Mandal and CBM University, ever ready to support and encourage such event. Any event cannot be possible without financial assistance. We are heartily thankful to Good Cost. Without their generous financial support, it would not have been possible to organize such a webinar. I'm very thankful to all the eminent speakers for accepting our invitations and spare a valuable time from their busy schedule and satisfy to everyone with their knowledge and expertise. We are highly grateful to our enthusiastic team of teaching and non-teaching staff, student volunteers and prayer team for their dedicated work, even though I'm also including the MOC team for their dedicated work for making this event successful. Once again, I'm very thankful to everyone whose contribution has made this webinar as a successful webinar. Now, I would like to officially end this event. Thank you very much to everyone.
Thank you,
Neeta,
sir.
Can we ask participant to keep on their camera so that we can take at
Yes,
least one
sir.
or two
I was about to announce that, sir. I request all the participants to kindly turn on their camera so we can take a screenshot of it. Everyone, turn on your camera. Everyone, turn on your camera so we can take a screenshot.
One thing I want to convey the message. All of you are looking such a big cupboard behind Chaudhary sir. So if you want to have something patent innovation, you have to read a lot. So my dear participants, be ready for reading a lot to interpret and to exercise. Is it? Wish you good luck, all of you participants, for future patentees. Okay.
Okay. I hope you all have enjoyed the informative webinar, and you all have to fill the feedback form, which is a step to collect the certificate, and a link is provided in chat box. And those who have successfully completed and filled the feedback form, they will receive the certificate within 4 to 5 working days. And thank you once again, and have a great evening ahead. Thank you so much.
Thank you so much.
Thank you once again, sir. Yes, sir.
Thank you, everyone.
Once you fill the feedback form, you can leave the meeting.